Okay, hello everybody. Hello, hi. Sorry, I'm trying to get the New York order printed, and my printer is so mad at me. I don't know that I've seen a printer that angry before. It's a lot. Hello, hi Deborah. Hi, welcome. Good to see you, everybody. Good to see you. Hopefully, you will be able to bear with me here for just a little bit. I'm still waiting for the second half of this New York order to come out of my printer, which my printer's making a sound I've never heard before. So it's interesting. It's a unique experience. Hello, good evening, everybody. Good evening. Good to see everyone. All right, so let me just finish getting sorted out. Okay, so yes, good evening. Good evening, everybody. Hello. Oh, good. Oh, yeah, I'm just, my printer. Oh, my poor printer is so, is so unhappy. But we'll get there. We'll get there. Yes, bonjour. Good to see you. Oh, my goodness. Yes. It's, but it's fulfilling its destiny. So that's okay. So I had gone, just for those who are just joining, I had gone on earlier today to go through Trump's response motion. Now, I did want to go ahead and take us through that response motion again for anyone who may have missed it. So I am going to take us through that motion. But we also have this new order out of the New York case. So I think we can go through both of those. Oh, thank you. I don't know how she laughs. I will have to look into that. But you make my day. Oh, that's so sweet of you to say that. That's so sweet of you to say. So I do have both of these different pieces to go over tonight. So I'm still waiting on the rest of the New York case to finish printing. So I can go ahead and get started here. Again, some of you may have joined me first thing this morning. I wanted to kind of hop on as soon as I had seen the motion, but hopefully, hi Vicky. Hopefully everyone is okay in joining me again here for the response in opposition to the prosecution's motion for prior restraint. So yes, I think a lot of people, it was just kind of a last minute thing. I wanted to hop on this morning when I could and go through it. So I wanted to go through it again this evening. So I will go ahead and take us through his response motion, but then hopefully by the time I finish with that, then the New York order, I should have that ready. Yes, I've got that. Yeah, Linda, exactly. So I've got that order ready to go too. So I'll probably just do two parts here. Just do first the response, the opposition to that government's motion for prior restraints, and then I'll take us through this New York order. From Chicago, we love that. Fabulous. So I will go ahead. No, Dan, I typically go live on Mondays and Thursdays, but this week is going to be super busy. So with how busy it is this week, I'll probably be going live most days this week. So just to give everyone an update here on the trial calendar, we've got our New York civil case here, initial objections, although that's kind of already taken care of. That was set out. We have motions that are not motions in limine for Chesebro and Powell. Meadows' reply brief is due. We've got pretrial management due for Powell as well as Chesebro. And then on Saturday, we've got the government's response to defendants' opposition to their order. So it's just going to be a really busy week, so I'll be popping in to kind of go through these different orders just to make sure everyone knows where we're at. The DC ruling, what I've got is he did file his opposition to the government's motion. So I'll take everybody through that motion. And then the government has till Saturday to respond. So I'm just getting started. Now, I will go through that motion, but then after we go through this motion, I do have then the New York order, and I really wanted to kind of break this order apart and look through the what the judge has issued as an order. So I will be doing both of those things tonight. So the first part, I'll go ahead and go through this motion, which is his response, and then I will go through the judge's New York order. Okay, so we'll do both. Just be just a little bit patient with me here, and I'll make it through. So I want to make sure that anyone who may have missed the live, I did kind of a impromptu live this morning, but I want to make sure I go through his opposition motion. So I'm going to go ahead and get started on that. If everyone is ready for that. Yeah, I think my throat's doing okay so far. I've been definitely taking it easy. So, which my friends and family find hilarious, but thanks. So let me go ahead and dive in now. We've got, again, I'll be doing two parts. I'll go through this motion and then I'll go through the judge's order from New York. So this is out of the DC case. Remember, the government had filed a motion. Let's just make sure we've got the name of his motion correct here. So the government has a motion to ensure that extrajudicial statements do not prejudice these proceedings. That's the name of the government's motion. So anytime that they're going in to say a gag order, they're referring to this motion, which is not a gag order. It's a very, very specific, narrowly tailored motion request. But here you go. This is what the government filed. They filed this on the 15th. His response just came in on the 25th. So I'll take you through that response first and kind of break apart. So just making sure, am I in frame okay, everybody? Let me just double check before I get started. I'm trying to make sure I'm in frame well enough, but I've got a couple different angles I'm looking at. Yes, I've got the New York case. Okay, great. Thank you, everybody. Thank you so much. All right, so let me just dive on in then. President Trump's response in opposition to prosecution's motion for prior restraints. President Trump respectfully submits this response in opposition to the prosecution's motion to impose unconstitutional prior restraints on President Trump's political speech, called the motion, document 55, seeking the proposed gag order. Now, this is the language that he is using, all right? Let's just keep that in mind. He's renaming the document. This is the actual document name here, and he's renaming it the gag order. So, on August 1st of 2023, the prosecution publicly released a 45-page speaking indictment. Speaking indictment is offensive. It's trying to state that it's not a particularly legally done indictment, that it's one made more for publicity rather than for, an actual criminal indictment. That read very much like a campaign press release. As if the indictment's media talking points were not enough, prosecutor Jack Smith then held a press conference to deliver an incendiary attack upon President Trump, falsely claiming that he fueled an unprecedented assault on the seat of American democracy. This inflammatory rhetoric, which violated long-standing rules of prosecutorial ethics, was then repeated daily by media publications across the country. Following those efforts to poison President Trump's defense, the prosecution now asked the court to take the extraordinary step of stripping President Trump of his First Amendment freedoms during the most important months of his campaign against President Biden. The court should reject this transparent gamesmanship and deny the motion entirely. Introduction. For hundreds of years, our country has embraced the core value that the government has no power to restrict expression because of its message, its ideas, its subject matter, or its content, which is a blatantly false statement. Just putting that out there. This freedom from government censorship is a fundamental to our national ethos, and it can hardly be doubted that the constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office. Tossing these foundational principles aside, the Biden administration charged President Trump, which is false information again, the leading contender for the 2024 presidential election, for statements he made as president. Now keenly aware that it is losing that race for 2024, the prosecution seeks to unconstitutionally silence Trump's, but not President Biden's, political speech on pain of contempt. Do you remember we have a prior order in the DC case already discussing the amount of language that can be used, just FYI. In support, the prosecution presents nothing but pretexts, claiming that the court must muzzle Trump to ensure that, one, the prosecution, the court, and the witnesses are not intimidated by political criticisms, and two, the District of Columbia citizenry, who voted by margin of around 95% for Biden in the 2020 election, which should not be relevant at all in a criminal trial, do not magically transform and become biased in President Trump's favor. The prosecution does not present one shred of evidence to demonstrate either of these claims, let alone enough to establish, as it must, a clear and present danger to the administration of justice. Neither the prosecution nor the court are reluctant to proceed with this case, and none of the public figures the prosecution references in its motion have refused to participate either. Just the opposite. These individuals appear to relish the notoriety they have gained through their proximity to Trump, variously writing books about their experiences, appearing on interviews with national media, and even running for president in their own right. Similarly, despite repeatedly claiming Trump's statements threatened the impartiality of the Venere, the prosecution does not identify a single potential juror who has allegedly become partial against the government due to President Trump's statements. Now, let me just make a note here that we don't know who the jury pool is going to be. The Venere just means it's the entire community of Washington, D.C. So the entire area, 700,000 people. So we don't know. So there's no way to know that there's a single potential juror. We just don't have that information yet. Worse, the proposed gag order lacks any semblance of narrow tailoring, sweeping in, for instance, all disparaging statements about any potential witness, regardless of subject, and including individuals who are actively waging political campaigns against Trump. And it does so in a unilateral way, preventing President Trump from defending himself in political arena, while giving President Biden and his surrogates, including those in the corporate media, free rein to say whatever they want, all for no legitimate reason. The purported goals of the proposed gag order would not be served by the order itself. The media would still feature this case and the prosecutors, the courts, and potential witnesses, yet unidentified by the prosecutors, would still be criticized in the public arena. The prosecution, therefore, cannot come close to eliminating the exact source of the evil it purportedly seeks to remedy, which is a lot. At bottom, the proposed gag order is nothing more than an obvious attempt by the Biden administration to unlawfully... Again, why is the Biden administration being brought up here? We have a prosecutor here. We don't have a presidential administration. To unlawfully silence its most prominent political opponent, who has now taken a commanding lead in the polls. Indeed, this very motion came on the heels of adverse polling for President Biden. His administration's plan is quite simple. Unleash a 45-page speaking indictment, which again is offensive, discuss and leak its talking points to the press. Now, the talking points weren't all leaked. It was the entire indictment itself. And then cynically attempt to invoke the court's authority to prevent President Trump and those acting on his behalf from presenting his side of the story. To the American people during a political campaign, this desperate effort at censorship is unconstitutional on its face. Here's the applicable law, such that it is. Now, as I have gone through this before, we just have quotes that he's pulling from these different cases. So not particularly persuasive, but Here we go. Even among First Amendment claims, gag orders warrant a most rigorous form of review because they rest at the intersection of two disfavored and presumptively unconstitutional forms of expressive limitations, prior restraints, and content-based restrictions. And again, keep in mind what he is calling the gag order is this motion to ensure that extrajudicial statements do not prejudice the proceedings. So that's what he's referring to as the gag order. In light of these twin presumptions, gag orders must survive strict scrutiny. Now, an interesting piece here, of course, with strict scrutiny, which is our highest level of scrutiny involving race and constitutional questions, he's citing Erwin Chemerinsky. Now, if memory serves, Chemerinsky served as, was trying to do an amicus brief in favor of Trump in the DC situation. So I'm not sure that he is an unbiased source, even though he is, one of our most well-known scholars in constitutional law, but we're citing something that was written, a law review article back in 1997. So I think that's really worth noting here, the role that this particular person is playing in these proceedings. So, strict scrutiny in turn requires the prosecutors to prove the restrictions is narrowly tailored to serve a compelling state interest. Again, I'm not sure strict scrutiny is the proper standard here, but he's going on about that. When the government restricts speech, the government bears the burden of proving the constitutionality of its actions. The prosecutors must meet both exacting standards to ensure that the communication has not been prohibited merely because public officials disapprove of the speaker's view. Again, I'm not sure that's particularly relevant, but, to each their own. In the context of the pending litigation, the prosecutors can only establish a compelling state interest by proving the speech at issue constitutes a clear and present danger to the administration of justice. This requires far more than just speculation regarding potential harm. Rather, the prosecution must proffer a solidity of evidence proving the danger is not just remote or even probable, but imminently imperils the administration of justice. What emerges from these cases is the working principle that the substantive evil must be extremely serious and the degree of imminence extremely high before utterances can be punished. Okay. And then we're quoting another case here. I'm not going to read through this case because I don't particularly find this to be relevant, honestly. I have read through it before and I'm not sure it's applicable here. So we're quoting more case law. According to the Supreme Court, has consistently rejected the argument that out-of-court comments concerning pending cases or grand jury investigations may be censored. Again, we're quoting this case, rejecting a likelihood of prejudice standard, holding that the exacting, clear, and present danger test applies. We see no legitimate reasons for a lower threshold standard for individuals, including defendants, seeking to express themselves outside of court than for the press. Again, we're citing a 1975 case here. We've got more case law being cited as well. So going into the clear and present danger test, which later he goes into the Brandenburg test, which is more accurate than the clear and present danger test. So this is just kind of going on a bit about that. So we'll keep moving on here. Got to keep this train moving. Again, so quoting more case law here, courts require a showing of a clear and present danger or a serious and imminent threat. Now, both of these pieces, that's more appropriate. So we'll bump back into actually what the law says to a fair trial before restraining litigant speech. And that bumps us to number 3. The prosecution inoppositely cites Gentile v. State Bar of Nevada to suggest it must meet a lower but still quite high standard of a substantial likelihood of materially prejudicing and adjudicative proceeding. Gentile, however, addressed the First Amendment rights of attorneys, not parties. This is really important to remember because he's going to cite this case over and over and over again. But he's saying here, First Amendment rights are only applicable in this case to attorneys, not to parties. So let's just take a note of that. Thus, much of the reasoning in Gentile justifying a lower standard for regulating attorney speech in pending cases does not apply to non-attorneys. and the case provides no cause to limit the speech of the parties. Again, we're just pulling some case law pieces out here, and so we'll bump back up. The thread running through all of these cases is that prior restraints on speech and publication are the most serious and the least tolerable infringement on the First Amendment rights. Thus, even where prior restraint is imposed to protect another vital constitutional guarantee, such as the right to a fair trial, the explicit command that the freedom to speak and publish shall not be abridged remains of paramount importance, and the presumption against the abridgment continues intact. And then we're citing more case law here. So, bumping down, he's using the Shepard case. The prosecution relies on Shepard v. Maxwell to justify depriving President Trump of his free speech rights, but Shepard did not concern the First Amendment. Rather, it addressed the need to protect a defendant's due process rights from a carnival atmosphere at trial. The prosecution has no parallel due process right. So, meaning that the motion does not pit the two constitutional guarantees against each other, but rather attempts to subordinate President Trump's free speech rights in favor of the prosecution's preference for silence. So, what they're saying here is if you have to pick between due process and freedom of speech, the defendant is saying freedom of speech is more important. But they're also saying that the prosecution doesn't have this necessary right to due process. And so the prosecution shouldn't be concerned about that, which I think is very fascinating. Very fascinating. So here we go. Moving on to page 8. Here's the argument. So, President Trump's posts do not endanger the administration of justice. Throughout its motion, the prosecution complains that President Trump's political statements undermine confidence in the criminal justice system, which it asserts somehow justifies the proposed gag order. The prosecution cites no authority in supporting this bizarre claim, nor can it, as the Supreme Court has repeatedly emphasized, speech critical of the exercise of the state's power lies at the very center of the First Amendment, citing that Gentile case again. This includes criticism of the court and special counsel. And this is a direct quote. The judicial system, and in particular our criminal justice courts, play a vital part in the democratic state, and the public has a legitimate interest in their operations. It would be difficult to single out any aspect of government of higher concern and importance to the people than the manner in which criminal trials are conducted. Public awareness and criticism have even greater importance, whereas here, the criticism questions the judgment of an elected public prosecutor. Our system grants prosecutors vast discretion at all stages of the criminal process. The public has an interest in its responsible exercise. And that's quoting the Gentile case again. The prosecution would silence President Trump amid the political campaign where his right to criticize the government is at its zenith, all to avoid the public rebuke of this prosecution. However, above all else, the First Amendment means the government has no power to restrict expression because of its message. That is incorrect. That is a false statement of law. Its ideas, its subject matter, or its content. The prosecution may not like President Trump's entirely valid criticisms, but neither it nor this court are a filter, that's also incorrect, for what the public may hear. Rather, the very purpose of the First Amendment is to foreclose public authority from assuming a guardianship of public mind. In this field, every person must be his own watchman for truth, because the forefathers did not trust any government to separate the true from the false for us. I don't even know about that. I don't even know if that's correct or not. That's a lot. If the prosecution wishes to avoid criticism for abusing its power, the solution is simple: stop abusing power. The Constitution allows no alternative. Actually, the prosecution isn't mentioned in the Constitution at all, but whatever. 6, down here, enforcing confidence in the judicial system through censorship is repugnant to the First Amendment in every respect. However, even if it were compelling government interest, the prosecution utterly fails to establish that any confidence President Trump's comments. So I think that's an interesting point. To satisfy strict scrutiny, harm must not be speculative or assumed, but rather demonstrated through compelling interest. Compelling evidence. And then he's citing this case here. So there's that. Yeah, I don't know what's going on with the Constitution. I wish they would read it before they start quoting it incorrectly. That would be my preference, but to each their own. Okay, A, President Trump has not intimidated anyone. Next, the prosecution argues without evidence that it needs the proposed gag order to prevent the purported intimidation of the prosecution, the court, and potential witnesses. The claim is meritless. First, it's absurd to suggest the prosecution and the court are intimidated by critical social media posts, let alone to such an extent that it constitutes a clear and present danger to the administration of justice. The prosecution does not point to a single prosecutorial or judicial function that has been impaired due to the cited social media posts, or otherwise suggests that it would be unable to fulfill its duties absent proposed gag order. All right, so let's just take a break for a second here, everybody. Let's just take a break. Let's just look through this order that Jack Smith put in here. Defendant has a history of inflammatory and misleading statements that he knew or should have known would cause others to harass and harm perceived critics or adversaries. So that's one whole section with direct quotes and citations and direct posts and what happened to people after those posts were made. Posts attacking, undermining, attempting to intimidate prosecution. Deranged Jack Smith is going before his number one draft pick, the judge of his dreams, who must be recused in an attempt to take away my First Amendment rights. This despite the fact that he and the DOJ and his many thug prosecutors are illegally leaking everything and anything to the fake news media. So it just gives you a little insight into none of the... They're saying there's not a single prosecutorial situation. I think there are. I'm just saying. I think there are. Every hearing in this case has gone forward on schedule without incident, and there is zero reason to believe that will change due to President Trump's political expressions. Also, as a quick side note, didn't we have someone in Texas that tried to go after this judge? Wasn't that this case? That wasn't the Florida case, right? That was this case, wasn't it? Where we had that woman who was charged with making threats to the judge. Yes. Okay, it was this case. Okay, got it. All right. So this idea of not a single instance. All right. So not a single prosecutorial. All right. Here we go. We're going to keep on moving here. Oh, Chuck and Nick. Okay. Similarly, no witness has suggested he or she will not testify because of anything President Trump has said. To the contrary, witnesses appear eager to share their expected testimony with the media and will undoubtedly testify at a potential trial, if called to do so. Nor has any witness suggested that President Trump's protected statements have influenced his or her testimony. A deep breath. I'm trying to get through so my voice doesn't go out, so I'm rushing a little bit. Sorry about that, everybody. I'm having a bit of a voice issue lately. As the prosecution baselessly suggests, this is entirely unsurprising as President Trump has never called for any improper or unlawful action. Quite the opposite. The prosecution's cited posts show that President Trump has been nothing but supportive. No, I just added that. I just added that part. I laugh out loud. President Trump intends to redress the unfairness of this proceeding through legitimate means. This includes, for example, filing motions with the court, a form of relief that President Trump has every right to pursue and talk about. This is a far cry from the type of true threat the prosecution would need to show to justify a prior restraint. Unable to identify any instance where President Trump uttered any threat, the prosecution points to others, claiming President Trump knows that when he publicly attacks individuals and institutions, he inspires others to perpetuate threats and harassment against his targets. Again, the prosecution offers no evidence of any causal connection between his speech and the alleged unlawful acts of others to support this meritless claim. Regardless, it goes without saying that the Constitution does not permit the censorship of President Trump for the unprovoked acts of third parties. Now, nowhere in the Constitution does it say that. And no such alleged act can justify a prior restraint of President Trump. Indeed, indeed, the Supreme Court consistently holds that speech cannot be prohibited based on an incitement theory unless it's directed to inciting or producing imminent lawless action and is likely to incite or produce such action. This is under the Brandenburg test. So we have the Brandenburg test finally coming out. Right. The prosecution does not and cannot explain how President Trump's statements would provoke any reasonable listener to lawlessness or otherwise fall within the small class of fighting words that are likely to provoke the average person to retaliation and thereby cause a breach of peace. And then we're just citing case law here. Rather, President Trump's statements are pure expressions of dissatisfaction with the policies of this country that are situated at the core of our First Amendment values. Criticism of prosecution witnesses, likewise, is core protected speech absent a true threat. That's not completely true. I don't know. We've got witness tampering, right? Again, the First Amendment requires far more than bare speculation that third parties might interact with the individuals President Trump comments on. Instead, the prosecution must proffer a solidity of evidence proving President Trump's statements immediately imperil the administration of justice. That means proving genuine material harm to this proceeding and drawing a direct causal link between that alleged harm and President Trump's protected speech. The prosecution has done neither, but even if the prosecution could meet this test, identifying some utterance of a true threat or incitement sufficient to satisfy the Brandenburg standard, and it emphatically cannot, that would only justify a very narrow restriction on the specific language at issue. It would not allow, as the prosecution demands, categorical restrictions on all disparaging statements regarding the prosecution, the court, an unknown set of potential witnesses, and certainly not all comment on this case. Finally, the prosecution bemoans the disparaging messages. Why would they put citation omitted? I don't know, because it's sloppy. Their citations are a mess in here. Their string citations are a mess. Their footnotes are a mess. So I guess they felt it wasn't important. As long as you're able to find where the exact quote's coming from, you're usually okay, but I'm not sure. I would omit citations in a brief of this caliber, but that's just me. Yet the prosecution seeks only to bar President Trump from speaking. Such inequitable restrictions offend the First Amendment on their face and have no place in our jurisprudence. They don't have a citation to quote. Typically, yeah, it's pretty sloppy work. President Trump's post will not prejudice the jury. The prosecution next speculates that President Trump's public statements could affect potential jurors and the impartiality of the jury pool, but fails to explain how. The prosecution's view, President Trump simply talking about a witness who might be a public critic, author, or political opponent would prejudice the jury through improper bolstering and impeachment. Let's just take a moment again while we follow up here. We have motion at 16. So let's just take a look at what he's talking about. Okay, so motion, this is the government's motion at page 16. So, a series of lengthy, detailed interviews. Many of the statements lead counsel, identifying the merits of the case. Regarding order here, the government's unaware lead counsel making any additional public statements. Counsel should therefore enter the order. Nope, I don't see that. Bolstering or impeachment, motion at 16. I'm not sure that's a proper citation here. That is not the law, and no authority permits a blanket gag order that would prevent a defendant from exercising his First Amendment rights. For good reason, an impartial jury need not be wholly unaware of information, including potentially prejudicial information outside the record. Prominence does not necessarily produce prejudice, and juror impartiality does not require ignorance. Okay, sloppy? Yes, it is. It is as sloppy as you think it is. It is, yes. When jurors have been exposed to extensive and prejudicial publicity, they are able to disregard it and base their verdict upon the evidence presented in court. And let's all remember that when they start talking about the jury pool not being good. Further, to promote impartiality, the law empowers the trial court to ensure fair jury trials using a number of tools short of gag orders, including enlarged jury pools, voir dire, changes to trial's location or schedule, cautionary jury instructions, and, in more unusual circumstances, sequestration. So he's just going into what a court can do. Okay. The Supreme Court discussed many other alternatives to prior restraints in this case, including a change of trial venue to a place less exposed to the intense publicity, postponement of the trial to allow public attention to subside, searching questioning of prospective jurors to screen out those with fixed opinions as to guilt or innocence, the use of emphatic and clear instructions on the sworn duty of each juror to decide the issues only on evidence presented in open court, and the sequestration of jurors. So I'm not sure if these are all things that he's wanting to have happen. He's wanting a change of view. Or a venue. He's wanting them to wait until publicity dies down. Like, okay. When a plausible, less restrictive alternative is offered to the content-based speech restriction, it is the government's obligation to prove that the alternative will be ineffective to achieve its goals. The prosecution has not demonstrated why any of the plausible alternatives above would be inadequate or offered a single less restrictive alternative to a near complete gag order that would preclude any comment on these proceedings or potential witnesses. This is insufficient. The prosecution cannot just claim the proposed gag order is narrowly tailored. It must prove that. That's true. All right, prove that it is the least restrictive method. Hydrate. Yes, one moment, please. Hydrate. This particular motion is just not that well written. I mean, I just want to, I'm holding back to take point deductions. I'm just saying. All right. The prosecution falls hopelessly short on meeting this high burden. The question, therefore, is neither whether a case has garnered public attention nor whether public discussion of it risks revealing potentially prejudicial information. Guidance is the critical concept. The question is whether the judge finds it likely that he or she will be unable to guide a jury to an impartial verdict. If judges can guide the jury to an impartial verdict, then no gag order may issue. Now, let me just pause another moment. Isn't this the same judge he's asked to recuse herself? I'm just saying. I mean, he's saying the judge will be able to take care of business, but he's like already asking her to recuse herself. I gave the paper an F. Yes. Well, it's not great. This is not a great example of legal writing here. I'm just saying. Okay. Here, the prosecution has not pointed to any statements by President Trump, as distinct from the countless statements by others about these proceedings, that present a danger of necessity, gravity, imminence, or likelihood necessary to warrant a violation of his First Amendment rights. This is Trump's response to the government's request for basically enforcement of the judge's order that she had issued very early on. In the indictment, as part of an obvious strategy, launched false and derogatory public accusations against President Trump. So, false and derogatory public accusations, but this was an indictment by a grand jury. Let's just remember that. Which the prosecution then expanded with gratuitous out-of-court statements wrongly insinuating that President Trump was responsible for the events of January 6th, an allegation not made in the indictment. In this respect, the prosecution and its media allies represent a far greater threat to prejudice to the venere than anything President Trump has or will say, particularly in the District of Columbia. Trump, his counsel, and agents have the right to counter this harmful publicity with public statements. Public statements of their own. Oh, look, I even got it right. Okay. And then again, defendant's attorney sought only to stop a wave of publicity he perceived as prejudicing potential jurors. So he's citing case law here. Such efforts, far from prejudicing these proceedings, protect President Trump's rights in our court of free speech. I don't think they really understand this free speech argument. I think somebody needs to firm that up with them a little bit. I mean, I would highly recommend that. In sum, for alleged jury influence to justify a prior restraint, the prosecution must establish that Trump's political commentary irrevocably biases district citizens against the Biden administration prosecution. Oh. Yeah, such that voir dire and other alternative remedies cannot remedy. Because the prosecution fails to meet this heavy burden, the proposed gag order is unconstitutional. All right, the proposed gag order is not narrowly tailored. And I'm not going to spend too much time on this because I have gone through this before, and he's just directly quoting from these different cases. There is no analysis. It's just a quote, a citation, a quote, a citation, a quote, a citation again. So, and even going into, for example, a grammatical structure that relies on the classic terms of degree that have no settled usage or tradition in interpretation of law. So this particular piece of it I have found to not be very helpful in understanding. Yeah, rhetoric quotes, exactly, when you're trying to fill in space. So that bumps us here. The proposed gag order does not meet either of these tests, which, again, I'm not sure that the tests were applicable, actually. It is sweepingly broad, and many of its terms are undefined. For example, the prosecution proposes that President Trump and his attorneys be restricted from making or authorizing any statements that pose a substantial likelihood of material prejudice. This is not the only wrong standard. This is not only the wrong standard, but it is vague on its face, providing no settled boundaries and utilizing prohibited classic terms of degree that leave Trump to guess at what the prosecution or the court might consider substantial or material, despite obvious disagreement on those issues. Determining whether a single specific statement poses a substantial likelihood of material prejudice is a difficult, fact-intensive question that courts struggle to resolve. To expect President Trump and his counsel to make that judgment in real time every time he speaks is utterly intolerable. I don't know. I mean, I guess if you're in this kind of a situation, it's like you should be careful about what you say, right? But, whatever. Let's be clear. The prosecution hopes to create a contempt trap for President Trump and his attorneys. All right. Although the prosecution offers some examples of conduct it would consider prohibited, it simultaneously cautions the examples are non-exhaustive. Citing such statements include but are not limited to. Further, the prosecution's examples are intentionally vague in order to chill the First Amendment rights of President Trump and his counsel. I'm just not impressed with the writing here. Contempt trap. Yeah, it's good. I think he created that for himself. For instance, the prosecution would prohibit any statement regarding the identity, testimony, and credibility of prospective witnesses. Now, again, I would remind everyone to look at the court's original orders regarding talking about prospective witnesses. That was already settled. The prosecution provides no list of prospective witnesses, nor does it define prospective. That group could include anyone who worked in the federal government around January 6th or anyone who was involved in the state election. Further, the broad characterization likely still does not include everyone who the prosecution could claim is a prospective witness. The group of prospective witnesses could also arguably include many of President Trump's political rivals in upcoming election. Thus, the proposed gag order places Trump at risk for contempt anytime he speaks about anyone relevant to his political campaign. That is plainly unconstitutional. I don't think it is plainly unconstitutional, and would inevitably lead to repeated and needless collateral litigation. Now that I would believe. Collateral litigation, absolutely. The prosecution's second example seeks to preclude President Trump from making or authorizing disparaging and inflammatory or intimidating statements regarding another wide and undefined set of individuals. The government does not define those adjectives, but by the content of the motion, it appears this example would include speech far below the constitutional requirement of clear and present danger to the administration of justice. The only speech the government appears willing to permit is basic case information communicated without comment. However, none of these cases the prosecution cites allows such a significant restriction on speech. Comment is at the very core of the First Amendment. Says who? Where's this? The very core of the First Amendment. That's bologna sandwiches. The United States Constitution may be inconvenient for the Biden administration. That's rude. That's rude and unnecessary. But public speech is in response to unfair and widely disseminated attacks as President Trump's right. Now that's just not true as well, but let's bump down here. Silencing President Trump would only make publicity regarding this case unfairly one-sided. All right. Finally, as stated above, the proposed gag order is entirely disconnected from the specific harms the prosecution alleges in its motion, and the prosecution makes no attempt to minimize the burden these sweeping restraints would have on President Trump's rights. Wow, he really is going on and on about these rights to have his side of the story told, even though, again, what's the prosecution been saying? I mean, other than that first day when the indictment was announced, there haven't been any statements that have been made. Why does this sound like the same one from this morning? Oh, Rowan, I'm sorry. I'm just going through it one more time. In short, the proposed gag order is unconstitutionally overbroad and vague in nearly every respect, and therefore fails to satisfy strict scrutiny's narrow tailoring requirements. 3. President Trump's attorney statements are entirely appropriate. All right. Little of the motion is devoted to President Trump's attorney's speech. Nonetheless, the prosecution seeks to place the same unconstitutional restrictions on counsel. In support, the prosecution cites comments made by President Trump's co-lead counsel in the immediate aftermath of speaking of the indictment and special counsel's false and derogatory public statements regarding President Trump. Again, that was that very first announcement of the indictment. That was it. Although the prosecution acknowledges defense counsel has not spoken recently on the subject, well, that's nice that they can acknowledge that, and nonetheless seeks to unlawfully restrain counsel's ethical duty to defend President Trump moving forward. Not surprisingly, the prosecution makes no mention of Smith's comments while seeking to censor defense counsel. Without question, the misleading allegations in the 45-page indictment sought to skew public opinion against President Trump in this historic case. I'm not going to spend too much time on this again because he's really just digging in at Jack Smith again for his comments that he made the night that the indictment first came out. Special counsel's improper out-of-court statements have the same effect. Despite the D.C. bar rule prohibition, he's even saying that he violated ethical rules by speaking about it. So let's bump down here. The prosecution has engineered negative press towards President Trump and now seeks to censor his counsel. Under settled law, counsel had and has the right to counter this false narrative with statements of their own. And citing the Gentile case again here. So he's just basically saying, Jack Smith said stuff when the indictment came out, so my attorneys should be able to say whatever they want, whenever they want. As recognized by the Supreme Court, public debate about criminal case almost always skews in favor of the prosecution. In the context of the general public awareness, honorary title of former president is allowed to be used. Yes, sorry, this is his motion, so I'm just using his language. These police and prosecution statements were no more likely to result in prejudice than the petitioner's statements, but given the repetitive publicity from the police investigation, it's difficult to come to any conclusion but that the balance remained in favor of the prosecution. Again, we're just quoting this case here. Thus, both the court and the disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment. I don't find that to be relevant at all. Indeed, there are circumstances in which the Supreme Court will accord speech by attorneys on public issues in matters of legal representation the strongest protection our Constitution has to offer. And that's out of context. And then we're quoting a bar rule regarding ethics. So I'm not going to play down into that role here. Counsel has met every ethical obligation imposed by the D.C. Bar Rule and otherwise consistent with the First Amendment and Gentile. But prosecution's baseless efforts to tarnish the reputation of counsel who has practiced before this court for 40 years should be condemned rather than entertained. Regardless, the court should decline to enter any order further restricting counsel's speech. Okay, so we're coming down into the very last part. Now, I think this last part is really the most important piece out of all of this, okay? So before he's saying, I got a First Amendment right, blah, 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 but this next part, I think, is really something to keep an eye on. So one of the things that the government had put into their motion regarding all of this was the fact that they were going out and essentially canvassing the DC area. So anybody who could potentially be a juror, just potential, not even called yet. So they were going out and talking to them. One of the requests the government made was that if you want to do that, fine, but talk to the judge first and let's have some parameters. So this is what he's arguing against. President Trump's attorneys should not be required to seek permission before conducting public polling or studies. In a related request, the prosecution asked that the court prohibit President Trump from conducting a public polling or jury study in the District of Columbia unless he, 1, discloses to the court a brief description of the intended methodology, B, all questions that will be asked in the pretrial survey poll or study, and C, the expected number of participants, which is absolutely a normal and acceptable request. Number 2, obtains court permission, and 3, completes all polling at least 30 days before the start of jury selection. So again, all completely reasonable in the real world. In support, the prosecution argues in conclusory fashion that this protocol is necessary to avoid prejudicing the venere. President Trump has no objection to informing the court of the dates and sample sizes of his polling in the District of Columbia. So just keep that in mind right now. He is going out and polling the people in D.C. who could potentially be part of the jury pool. We don't even know yet. We don't even know who these people are. 700,000 people in D.C., 400 will be pulled in. Out of those, 24 will be chosen. So they're just going and knocking on doors and saying, hey, what are your thoughts? However, he opposes the remainder of the prosecution's request. As an initial matter, jury studies and polling have almost no chance of influencing the jury. Washington, D.C. has almost 700,000 residents. A statistically significant sample size would ordinarily include only a few hundred people, meaning it is highly unlikely that any polled individual would be in the jury venere. Moreover, it would be simple enough to ask potential jurors during voir dire if they participated in any pretrial polling, which would adequately screen for any minimal influence a poll might have. Keeping in mind the purpose of polling and jury studies is not to influence respondents, but to get a true read on the community's opinions or feelings on certain issues. So this is a lot. This is a lot right here. This is something that I'm definitely struggling with when it comes to just polling random people. I don't know, maybe you'll be called in for jury duty, maybe you're not, but hey, let's talk. What's going on? Like, what? We're not campaigning here. This is a criminal trial. In addition, polls and jury studies commissioned by the defense counsel are work product, and some parts, if not all, are attorney-client privileged. Do you support... What? I don't even know what that means, Rich. I don't even know what that means. Help me out. Look up voir dire. Yeah, voir dire is an important part of that. It's sarcasm. You're going to have to make a sarcasm face, Rich. Let's all designate a sarcasm emoji so that I fully am aware. love your sarcasm. Because these days, it's hard to tell, my friend. It is hard to tell. Oh, my gosh. Some of these things that you think people are being sarcastic about, they are for real meaning it. He's being asked the question he thinks is being asked of the... Oh, yeah, exactly. I got you now. I got you. Yeah, just use a face. Yeah, whichever. We can all agree to a couple of different faces. Just use the emoji. That way I can gauge it. Oh my gosh. The sarcasm face. Yes, thank you. Thank you, everybody. That's so funny. All right. Back to polling the entire area and seeing if anyone has any thoughts. Make sure you put an emoji or you might get blocked. It's true. It's true. This is like a game of dodgeball when we're in here in this live. We don't know if we're ducking or if we're grabbing balls. We don't know what's happening. So put an emoji in so we know you're kidding. And then we can all laugh together. That's no problem. Oh, yes, there's lots. There's lots of great emojis. All right, here we go. Back into it. All right, we're polling people. All right, the government has not articulated a basis to overcome these privileges, which, I'm not really sure that there are appropriate attorney-client privileges when you're polling an entire community of people. All right, last page. Here we go. The lone circuit court opinion cited by the prosecution also does not support the notion that a district court should always review pretrial polling. The issue there was whether pretrial polling by the government deprived a defendant of a fair trial. That's not the issue here, as both parties have an equal opportunity to poll. Ultimately, the Collins court was satisfied because, as here, no one of the jurors who served on the jury was contacted, and the court specifically inquired as to this matter in voir dire. The court emphasized, although a survey of community attitudes may aid a party in deciding what to emphasize at trial, our adversarial system with its liberal discovery mechanisms does not permit a party to contrive a conviction that's not based on the evidence. There's no evidence that the government manufactured or tailored evidence based on the survey. All right, good enough. I hope that they remember this in the future. Preventing any polling 30 days before trial is also detrimental to the defense. With the immense pretrial publicity in this case, public opinion could sway dramatically as the trial approaches. That's just not how criminal trials work. You don't get to just go out and ask people. I mean, this is ridiculous. Thus, polling is most valuable if conducted close to the trial. What? What is this? 30 days before jury selection is an arbitrary and unnecessary restriction, and it does not matter when a person is polled if they will be queried during voir dire. The prosecution in this case already knows the population of Washington, D.C., and knows that it does not favor President Trump. So why are they polling then? If that's not it, then why are they polling? Any restrictions on pretrial polling would only work as a further disadvantage to the defense, which has the right to prepare for trial without prosecutorial interference. Accordingly, the court should reject the government's proposed polling order. I don't know if I agree with that. Here's the conclusion. The court should deny the motion in its entirety, given the significant First Amendment issues I can't even read. I've got to the end of it and I'm like, what did he say? What's this? The court should deny the motion in its entirety, given the significant First Amendment issues presented by the motion. Trump respectfully requests the court schedule a hearing at the first opportunity. Whew. All right. Goodness gracious. We made it somehow through this motion. And it was a struggle. It was a journey. It was a struggle. It was difficult, but we made it through somehow. Oh my gosh. This is a lot. It's just a lot. If it was well written, it would be a lot, but educational. But it's not. It's not well written. Oh my goodness. Hydrate. Yes, it was. All right, everybody. I'm going to hydrate and next up then, everybody, as we let this kind of sink in to our brains, then I will dive into this New York order that we just got down. So give me just a few minutes. I'll be right back. My printer should be done with the rest of the order. Whew, okay. All right, so does anyone have questions? I kind of jetted through that motion. I didn't want to give it too much time. But still, the amount of time that it was due, that's a lot of numbers. I know, right? I know. All right, let me just make sure I've got everything here in order. All right, so this order, oh my gosh, I was hunting this down. Can one of you lawyerly types tell me the purpose of polling is? Yeah, I mean, they're just trying to get some idea of what people's thoughts are in general in the area. But to do it at this degree is a lot. I've never seen it done like this before. But again, I don't do trials in DC. Maybe they do this. Can't polling determine whether or not the case can be conducted in the area? I suppose they could use it as evidence to show that there's an issue and that they need a change of venue, but there's a lot of ways you can go about doing that. I suppose it would be helpful for that, though. Sure. Makes everything up as he goes. Yeah, it's a lot. It's a lot of firsts going on. Yeah, it's a lot. All right, they do look like a mess. All right, everybody. So, okay, here we go. Here's what we know so far. I've not read this order. Again, it just came out. I was hunting for it. So we've got the New York civil case. We had today objections to evidence and disclosures. And then tomorrow we've got the final pretrial because the trial starts next Monday. So it starts Monday. So this order just came down from Judge Engoron with regards to they had a fight over motions for summary judgments, right? So does everyone know what a motion for summary judgment is? I'm not sure. I don't want to assume people do know or don't know. So is everyone familiar with the motion for summary judgment? No. Okay. Yes. No. Okay. Yes. No. Okay. All right. So let me just explain. Right. So we have Attorney General the judge makes the decision. Right. So we've got Letitia James. She's filed this $250 million suit against Trump and all of these people. Now, they both went into court last week on motions for summary judgment, meaning they both said to the judge, hey, we've given you enough information that you should be able to decide the case for me. Now, the state said that and the defendant said that. So what's come out is this order now from the judge. After he went through that information, he's made this decision. So here's his decision and then order on the motions, and those are the motions for summary judgment. So it's partially been decided, but not completely. So let's kind of break it apart here and figure out what's happened. So we've got motion dates for September 5th, August 30th that were set out. So the following e-file documents listed and the document number. So yeah, there's a whole bunch of documents listed here. This is, again, the first time I'm looking at this too. So we'll go through this first stack of numbers here. Now, also, this is Trump Jr., Eric Trump, Weisselberg, McConney, irrevocable trust, organization, holdings, and so on. So with these first set of documents, we have a partial summary judgment. So, and we'll read through and figure out what that means exactly. Now, according to these different motions, we have a full summary judgment. So this is only partial. So partial has been granted. That means part of it's still going to go to trial. For these documents, it has, in these motions, a full summary judgment has been granted. And then next, we've got these documents, and apparently sanctions have been ordered for that. So we'll go back in and look and see what has been decided, what hasn't been decided yet. But sanctions have also been awarded. Yes, they did not ask for a jury trial in time. For some reason, there's been no jury trial set for this. So, for whatever reason. Yeah, sanctions. Well, and he's already gotten sanctions, too, out of the Florida case. We already talked about that. The Trump v. Clinton case, he was given about $1 million in sanctions in that case as well. So, all right, upon the foregoing documents, it's hereby ordered the defendant's motion for summary judgment is denied. All right, so no summary judgment for defendant, but the plaintiff's motion for partial summary judgment is granted in part, and the plaintiff's motion for sanctions is granted in part, and then he'll break down the details. So let's go through what each of these means. So I am going to really take my time going through this so I can get anybody's questions for anyone who has questions along the way. So give me 1 second here. I may just have to. Okay. I'm trying to get us back up operational here. Yes. Let me pour some wine. Oh my gosh. Yes. All right. Are we lined up? I got chips and salsa. I love it. Oh my gosh. Oh, I love it. Got my drink. Okay. All right. Excellent. All right. Good to go. Let's dive in. All right. This action arises out of years-long investigation that plaintiff, the Office of the Attorney General of the State of New York, conducted in persistent fraud by preparing, certifying, and submitting to lenders and insurers false and misleading financial statements, thus violating New York Executive Law 6312. All right, so I will probably highlight as I go. I always use certain colors for certain things, so you'll just have to forgive me for that. Procedural background. In 2020, the Office of the Attorney General commenced a special proceeding seeking to enforce a series of subpoenas against various named defendants and other persons and entities. This court presided over that proceeding and issued several orders compelling compliance with the AG subpoenas. During that proceeding, the AG and the Trump Organization entered into an agreement, which broadly speaking told the statute of limitations from November 5th through May 31st. So that's really important to note when our statute of limitations were told. So let's just highlight that because we don't want to miss our statute of limitations. So tolling just means it paused. We paused the statute of limitations by mutual agreement. On November 3rd of 2022, this court found preliminarily that defendant had a propensity to engage in persistent fraud by submitting false and misleading statements of financial conditions on behalf of defendant Trump. Accordingly, the court granted a preliminary injunction against any further fraud and appointed the Honorable Barbara S. Jones, retired, as an independent monitor to oversee defendants' financial statements and significant asset transfers. We've kind of talked about that before a little bit. Defendants moved to dismiss the complaint. In a decision and order dated January 6th of 2023, and it's important to remember our dates as we go through this as well, this court denied the motion. Defendants appealed, resulting in a January 6th order wherein, Again, we got to keep track here where we're at. Wherein the Appellate Division, First Department, modified this court's order to the extent of 1, declaring that the continuing wrong doctrine does not delay or extend the statute of limitations. 2, finding that claims are timely against defendants subject to the tolling agreement if they accrued after the July 13th of 2014, and timely against defendants not subject to tolling agreement if they accrued after February 6th. And 3, dismissing the complaint as against defendant Ivanka Trump on statute of limitations grounds, finds that she was not an employee of the Trump Organization at the time at which the parties entered into the tolling agreement. Okay, so Ivanka was dismissed from the case because the statute of limitations agreement, the tolling agreement, she was not a part of that. So it wasn't because she wasn't involved, it was because the statute of limitations ran on her piece of the case. All right. The Appellate Division declined to dismiss any other defendants or any causes of action. So that's an important holding. We'll just keep that in mind again as we go through here. So everybody else was involved. Discovery ended July 28th of 2023, and the AOG filed a note of issue shortly thereafter. AOG now moves for partial summary judgment on its first cause of action for fraud under Executive Law 6312. Separately, plaintiff now moves pursuant to this rule to sanction defendants for frivolous motion practice. Ooh, frivolous motion practice. That's bad. Don't do that. I wonder if we're going to have more shotgun pleadings. I bet that's what's going to happen. Defendant also moved for summary judgment, seeking to dismiss the complaint in its entirety, which of course we know this was denied. So this was denied. Executive Law 6312 provides as here pertinent as follows. Whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transaction of business, the Attorney General may apply in the name of the people of the State of New York to the Supreme Court of the State of New York on notice of 5 days for an order enjoining the continuance of such business activity or of any fraudulent or illegal acts, directing restitution and damages, and in an appropriate case, canceling any certificate filed under and by virtue of the provisions of Section 440 Informal Penal Law or Section 130 of the General Business Law. The word fraud or fraudulent, as used herein, shall include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provisions. The term persistent fraud or illegality, as used herein, shall include continuance or carrying on of any fraudulent or illegal act or conduct. The term repeated, as used herein, shall include repetition of any separate and distinct fraudulent or illegal act or conduct which affects more than one person. All right, so that's the law that we're dealing with out of New York. Executive Law 6312. Now let's flip to the next page. Defendant's motion for summary judgment on all causes of actions. Ooh, this is going to be good. All right. Arguments defendants raise again. Again? Oh, dear. Would Ivanka be called to testify? She would have knowledge of the illegal acts. Absolutely. Yep. Just because she's not named in the case as a party doesn't mean she can't be called as a witness. Absolutely. All right. Standing and capacity to sue. Defendants' arguments that the AG has neither capacity nor standing to sue under Executive Law 6312, and that the disclaimers of non-party accountants, Mazars, insulate defendants, invoke the time loop in the film Groundhog Day. What? Did this judge just... What? Did he just quote Groundhog Day? What is happening? Oh my goodness. Oh my gosh, this is going to be crazy. What is happening? What? No. All right. All right. This judge. All right. The court emphatically rejected these arguments in its preliminary injunction decision and in its dismissal decision, and the First Department affirmed both. Defendants' contention that a different procedural posture mandates a reconsideration or a fortiori a reversal is pure sophistry. Sophistry? What is that? What word even is that? I don't know. Let's bump down. Indeed, the court made this crystal clear. Oh my gosh, this judge is mad. Oh my gosh. In its January 6th of 2023 order, when it found, here the issues of capacity and standing are pure issues of law and do not depend on a trial of disputed issues of fact. Simply put, who the instant parties are and what the law says, which determine capacity and standing, are not disputed issues of fact that need to be tried. That's harsh. Whoa. Whoa. Okay, so he's like, okay, unsophisticated. Wow, that's a lot. As this court and others have made abundantly clear, it is not disputed that the Attorney General is empowered to sue for violations of Executive Law 6312. Citing law here. Parens Patrae in Consumer Ambit. Defendants repeat the erroneous argument that the complaint must be dismissed because the AG cannot demonstrate the requirements of Parens Patrae action. How is that appropriate? Which is one of the public interest. Parens Patrae is a common law standing doctrine that permits the state to commence an action to protect a public interest, like safety, health, or welfare of citizens. Invocation of such doctrine or its requirements is not necessary, whereas here the New York legislature has specifically empowered the Attorney General to bring such an action pursuant to executive law. Well, it doesn't get more clear than that. Wow. So they can't even use the doctrine. They're like, it's actually law. That's a lot. That's a lot. All right, and we're citing this case here. It is undisputed that Executive Law 6312 gives the Attorney General standing to redress liabilities recognized elsewhere in the law, expanding the scope of available remedies. All right. People v. Trump, and this was decided December 16th. Even apart from prevailing authority, the language of the statute itself appears to authorize a cause of action like similar statutes that authorize cause of action. 6312 defines the fraudulent conduct that it prohibits, authorizes the Attorney General to commence an action or proceeding to foreclose that conduct, and specifies the relief, including equitable relief, that the Attorney General may seek. Oh my gosh. Oh, this judge. Yes, refer to your other cases. It's real bad when the judge is citing your own cases back to you. It's bad, yeah. That's not good. Oh my goodness. All right. Whew. In any event, even if compliance with the requirements of the Parens Patrae doctrine is necessary, which it's not, I got this judge. This judge is going to crack me up. I could tell already. The AG has easily satisfied those requirements, as it is well settled that in varying contexts, courts have held that a state has a quasi-sovereign interest in protecting the integrity of the marketplace. And then we're citing law here. Oh my goodness. Oh my goodness. And this is more case law he's citing here. The state's statutory interest under 6312 encompasses the prevention of either fraudulent or illegal business activities. Misconduct that is illegal for reasons other than fraud still implicates the government's interest in guaranteeing a marketplace that adheres to standards of fairness. Defendants' rehashed argument that the AG's complaint must be dismissed because it's not designed to protect consumers is unavailing. Yikes. And then we're citing another case here. Defendants claim that Section 6312 is limited to consumer protection actions is simply incorrect. The New York Attorney General has repeatedly used Section 6312 to secure relief for persons who are not consumers in cases that are not consumer protection actions. Defendants cite to the trial court decision People versus Domino's Pizza, which is not binding on this court. Oh no. Oh no. You don't want to use case law that's not binding. Come on. Oh my goodness. As authority for the proposition that any relief sought here should come in the form of private contract litigation, not a law enforcement action under the statute. Form of private contract litigation, not a law enforcement action under the statute designed to address public harm. However, Domino's is wholly distinguishable from the instant case. There, the court found that the AG did not establish that Domino's representations to franchises were false, deceptive, or misleading. Whoa. Whoa. Accordingly, wait. What is, I'm glad nobody's talking about me anymore, says Clarence Thomas. Accordingly, the court concludes, did you guys see that? Wholly indistinguishable because this case has to do with fraud and the Domino's case did not. That's really harsh. Okay. Accordingly, the court concludes that the AG has not established that Domino's engaged in the conduct that tends to deceive or creates an atmosphere conducive to fraud. Here, as discussed, the AG demonstrates that defendants repeatedly submitted fraudulent financial documents to obtain financial benefits, which otherwise should have not been received. Yikes. Defendants glaringly misrepresent the requirements of an executive law. Cause of action. Well, that's important to note. That's pretty significant. Okay. Defendants assert that the AG must show the practice is one likely to mislead a reasonable consumer acting reasonably under the circumstances. However, the word consumer does not appear anywhere in the reference decision, and the defendant's characterization of its holding is inaccurate. I like that. Let's bump down here. Although consumer does appear in the First Department's affirmance of the Northern Leasing, it does not advance defendants' proposition that Executive Law 6312 actions be consumer-oriented. It simply reaffirms that the test for fraud is whether the targeted act has the capacity or tendency to deceive or creates an atmosphere conducive to fraud. Oh my goodness. Northern Leasing confirms that the test for fraud is whether an act tends to deceive or creates an environment conducive to fraud. So we've got that set out already. So he's setting out the fraud test. There. So non-party disclaimers. Let's just highlight this so we can make sure that we get all of the pieces put together correctly. Yeah, New York is not messing around. New York is mad. New York is angry. Defendants yet again argue that AG's complaint must be dismissed because the SFCs contained language provided by non-party accountants, Mazars, that indicate that they have not audited or reviewed the accompanying financial statements and therefore cannot express an opinion as to whether the financial statements comply with the generally accepted accounting principles, or GAAP. However, as this court already ruled, these non-party disclaimers do not insulate defendants from liability, as they plainly state that Donald J. Trump is responsible for the preparation and fair presentation of the financial statements in accordance with accounting principles generally accepted in the United States of America, and for designing, implementing, and maintaining internal control relevant to the preparation and fair presentation of the financial statement. All right. As this court explained, it's November 3rd. Wow, this court's mad. Decision in order. The law is abundantly clear that using a disclaimer as a defense to a justifiable reliance claim requires proof that, one, the disclaimer is made sufficiently specific to the particular type of fact misrepresented or undisclosed, and 2, the alleged misrepresentation or omission did not concern facts peculiarly within the defendant's knowledge. So this is the test he's using, and he's already set that out. A plaintiff may not be precluded from claiming reliance on misrepresentation of facts peculiarly within the defendant's knowledge. And we're quoting case law here. As the SFCs did not particularize the type of fact misrepresented or undisclosed and were unquestionably based on information peculiarly within defendant's knowledge, defendant may not rely on such purported disclaimers as a defense. I'm confused but entertained, as am I, Deborah, as am I. In sum, the Mazars disclaimers put the onus for accuracy squarely on the defendant's shoulders. All right, so this whole thing is saying he had the law wrong and he didn't use the test properly. Can you explain each paragraph? Well, sure. Okay. All right, so how can I break this down? So Trump was basically saying here that the complaint needed to be dismissed because there were certain non-parties involved. And because of how they were put into the documents, it should be dismissed. The judge is saying that's not how we do things. This is the test. The test was satisfied, and therefore we cannot just dismiss the suit outright. So you're using the law incorrectly, is basically what they're saying here. Where to begin? Exactly. Oh my gosh. I award you no points. God have mercy on your soul. Yes, also accurate. Also. Oh my gosh. Yeah, exactly. You're using the wrong law. All right. So scienter and participation requirements. All right. So scienter means intent. So, Trump's entire argument here was saying, you know what, everybody kind of fudges a little bit on their finances. And, the AG's office is like, actually, that's not how it's supposed to be done under the law. And you fudged by like billions of dollars. So the judge here is going to talk about the intent that's involved next. Okay. So the scienter and participation requirements. Defendants erroneously claim that the Fletcher case stands for the proposition that the purported participation element of a cause of action under Executive Law 6312 is satisfied where the defendant directed, controlled, or ratified the decision that led to plaintiff's injury. However, Fletcher is not an executive law action. It was brought as a corporate tort, accordingly is not relevant here. So one of the elements Trump is trying to say is this case allows this intent element to toss the case out. The court just said, your case is wrong. That's how he just put it. He's like, that's not the right case. Defendants also incorrectly rely on another case for the proposition that merely providing copies of purportedly false financial statements is insufficient. However, as Brahmi was not brought pursuant to Executive Law 6312, its analysis regarding intent to deceive is irrelevant. So again, they're talking about his intent and the information that was involved in the paperwork, and the judge is saying you're relying on case law that's irrelevant. Again, your case law is no good here, sir. That's what he's saying. Good faith or lack of fraudulent intent is not an issue. So he's going further into that. So the next argument defense had was disgorgement of profits. So in flagrant disregard of prior orders of this court and the First Department, defendants repeat the untenable notion that disgorgement is unavailable as a matter of law. So again, they're trying to use this legal theory. This is patently false, as defendants are or certainly should be aware that the Appellate Division, First Department made it clear in this very case that we have already held failure to allege losses does not require dismissal of the claim for disgorgement under executive law. So we have another legal theory here that he's saying that New York didn't put out exactly how much damage or harm was done to them, And so the case should be dismissed. And the court is saying, we have held in this case already that that's not required. So why are you arguing it again? The defendants, nonetheless, rely on the trial court decision and People v. Direct Revenue for the proposition that Executive Law 6312 does not authorize the general disgorgement of profits received from sources other than the public. However, defendants neglect to mention that direct revenue was superseded and essentially overruled. Ooh, this is bad. All right. So again, the defendant's whole point in their motion for summary judgment is to get the case dismissed. Okay. So that's what Trump's trying to do. So he's using all these different legal theories. Another one of the legal theories, this disgorgement issue, which has to do with profits and so on. And he's relying on case law that is not good case law anymore. So first he used the wrong test. Then he used a theory that the court has already held in this case is not a theory he can use. Now he's relying on bad case law. Okay. So yeah, the fire hose approach. Exactly. So case law is bad. So that's not going to work. Also, fatally flawed is the defendant's reliance on People v. Frank, as it relies on the outdated proposition that Executive Law 6312 does not create any new causes of action, and thus the remedy of disgorgement is unavailable. However, in Trump Entrepreneur Initiative, in which at least 3 of the instant defendants were parties, the First Department unambiguously declared that the Attorney General is in fact authorized. Defendants incorrectly posit that under People v. Ernst, disgorgement is available under the Martin Act, but not under Executive Law 63. This is simply untrue. Again, he's really pushing this disgorgement issue. And the judge is saying, we've already ruled on this issue that you keep pushing forward over and over and over again. Your case law is bad. Your test is bad. We've already ruled. We've already told you what the test is. You're not using the test. It's wrong. Everything you're doing is wrong. Defendants correctly assert that the record is devoid of any evidence of default, breach, late payment, or complaint of harm, and argue that as none of the recipients of the subject SFCs ever lodged a complaint with the AG or otherwise claimed damages, disgorgement of profits would be inappropriate. So he's saying nobody ever complained about these numbers that we gave them that were bad. They never said that they were harmed in any way because of that. So there shouldn't be a case, is what the defendant is saying here. So let's flip and see. However, that's completely irrelevant. So the judge is like, oh my gosh, the judge is like, all of your arguments are bad. And your arguments are irrelevant. That's harsh. That's really harsh. I mean, we don't really need to get into the bits and bobs of complex business litigation here to be able to see what's happening here with this judge. So again, they're going through this idea of disgorgement, which again is one of the analysis of determining whether or not anybody was really harmed by these numbers that were inflated. Was anyone really harmed? And this is a type of harm that he's trying to gauge. And so the judge is just saying, that's irrelevant. It's just hilarious to me. All right, so let's move on. The judge is slapping him in the face. Yeah, he is. I mean, that's completely irrelevant. Not just irrelevant, but completely irrelevant. All right, let's talk about sanctions. Sanctionable conduct for frivolous motion practice. Now, we had this again, remember, in the Florida case where he and his attorney were sanctioned for almost $1 million. In response to both AG's request for a preliminary injunction and to defendants' motions to dismiss, this court rejected every one of the aforementioned arguments. In rejecting such arguments for the second time, this court cautioned that sophisticated counsel should have known better. Ouch. Ouch. You don't ever want a judge to say that about you. That's mean. Will there be a stay during the appeal? I don't know. I really don't know what's happening. This judge is so mad. I'm not really sure. And we've got so many different appeals that have been going on. We'll have to see how he presents it at the end. The court even went so far as to caution that arguments were borderline frivolous, even the first time the defendants made them. What? Whoa, the court specifically said that the arguments were frivolous the first time, and they made them repeatedly. That's bad. That's no good. However, the court declined to impose sanctions, believing it had made its point. Clearly, the court had not made its point. Apparently, the point was not received. I can't. I'm sorry. When you get a funny judge like this, he's so pissed off. One would not know from reading defendants' papers that this court had already twice ruled against these arguments, called them frivolous, and twice been affirmed by the First Department. Whoa, that's a lot. In its discretion, a court may award costs and financial sanctions against an attorney or party resulting from frivolous conduct. Defendants' conduct in reiterating these frivolous arguments is egregious. We are way beyond the point of sophisticated counsel should have known better. We are at the point of intentional and blatant disregard of controlling authority and law of the case. Can a judge hold the attorneys accountable for filing senseless arguments? Absolutely. That's what he's doing. That's absolutely what he's doing right now. He's so upset. He's like, wow, it's bad. This court emphatically rejected these arguments, as did the First Department, so the appeals. Defendants' repetition of them here is indefensible. Whoa. I have never seen a judge come down this hard like this before. This is really bad. Whew. Well, it looks like this judge has said like time and time and time again, and no one's listening. They don't like that when you don't listen. Pursuant to New York Administrative Code 130-1, the court, as appropriate, may make such an award of costs or impose such financial sanctions against either an attorney or a party to the litigation or against both. The provision further states that, for purposes of this part, conduct is frivolous if 1, it's completely without merit in law, cannot be supported by a reasonable argument for an extension, modification, or reversal of existing law. 2, it is undertaken primarily to delay or prolong the resolution of the litigation or to harass or maliciously injure another. Or 3, it asserts material factual statements that are false. Defendants' inscrutable persistence in re-presenting these arguments clearly satisfies the first of these 3 possible criteria. Whoa! When considering imposing sanctions, among the factors the court is directed to consider is whether the conduct was continued when it became apparent or should have become apparent that the conduct was frivolous, or when such was brought to the attention of the parties or to counsel. In its January 6th of 2023 decision and order, this court warned the defendant that their reiteration of those previously rejected arguments scattered across 5 different motions to dismiss was frivolous. Whoa! That's hardcore. That was set out in the order itself. So there's an order saying that your actions are frivolous. Yikes! In a last-ditch attempt to stave off sanctions, defendants have submitted an affirmation by the Honorable Leonard Austin, who had a supremely distinguished judicial career, culminating in 12 years on the Appellate Division 2nd Department. Justice Austin presents what is essentially a primer on the interplay between motions to dismiss and motions for summary judgment, and every point of law is valid. However, it's wholly invalid as a reason for this court to deny sanctions. Whoa! Oh my goodness. Oh dear. Oh dear. They're in trouble. All right. First, legal arguments are for counsel to make, not for experts to submit. Ouch. The rule prohibiting experts from providing their legal opinions or conclusions is so well established that it is often deemed a basic premise or assumption of evidence law, a kind of axiomatic principle. Ouch! That's harsh. Neither defendants nor Justice Austin has sought permission to file an amicus brief. In their own submissions, defendants have expounded on the law of capacity, standing, disclaimers, motions to dismiss, motions for summary judgment, and sanctions. The heft and prestige of legal lion adds nothing. Are judges usually this blunt? No! This is crazy. This is a lot. I have never seen anything like this before. So he's saying you have a legal expert in here who filed an amicus brief or an amicus brief without even asking permission. And so adding in this expert is not helping you at all. And shame on you. You should know this. Yikes. More importantly, the subject affirmation utterly fails to fit the specific facts of this case into the general principles it enunciates. In many situations, discovery in a complete record and the reversal of the burden of proof will turn the tide, requiring that a valid complaint be dismissed because there's no evidence to support it. But standing and capacity are legal questions, not factual issues. Crucially, while defendants have, by their own account, conducted extensive discovery and have created a complete record, they fail to point to a single fact that discovery has uncovered, let alone a single fact in the record that changes the calculus of their denied and doomed capacity and standing arguments. Whoa! Capacity and standing are not esoteric concepts. Whoa! Infants, oh my gosh. Infants, legally declared incompetents, and persons under certain legal disabilities are not allowed to sue. The New York Attorney General is none of the above. If my sibling or neighbor is harmed, I do not have standing to sue for his or her injury. Citizens may not sue to prevent government actions unless they may suffer some personal harm. 6312 was promulgated to give the Attorney General standing to sue on behalf of the people of New York to prevent or deter the precise type of fraud here at issue. Arguments to the contrary are risible. Whoa! Defendants' arguments that the factual record developed in discovery changed the landscape under which standing should be viewed is legally preposterous. The best that defendants could muster at oral arguments was to contend incorrectly that plaintiff cannot sue because the subject transactions were between private entities and nobody lost money. However, that is purely an argument on the merits, not an argument on standing. Taken to its logical extreme, absolutely any time a defendant denies liability, it could move to dismiss on the grounds of lack of standing. Exacerbating defendants' obstreperous conduct is their continued reliance on bogus arguments in papers and oral argument. The defendants' world, rent-regulated apartments are worth the same as unregulated apartments. Restricted land is worth the same as unrestricted land. Restrictions can evaporate into thin air. A disclaimer by one party casting responsibility on another party exonerates the other party's lies. The Attorney General of the state of New York does not have capacity to sue or standing to sue, never mind all those cases where the Attorney General has sued successfully. Under a statute expressly designed to provide that right. Oh no, oh my goodness. All illegal acts are ultimately, they stem from one untimely act and square footage subjective. What? This judge is so pissed. He's so mad. This judge is really mad. That is a fantasy world, not a real world. Oh my gosh. There's also a larger context to the sanctions issue. Several defendants are no strangers to sanctions and why courts are sometimes constrained to issue them. In the investigatory special proceeding, this court found Donald Trump in contempt of court and sanctioned him $10,000 per day for failing to comply with his discovery obligation. This court lifted the contempt after 11 days. Oh dear. The first department affirmed the contempt and fines. And they're reciting the case here. The financial sanction to compel compliance was a proper exercise of the court's discretionary power. It was not excessive or otherwise improper under the particular circumstances. In Donald J. Trump v. Hillary Clinton, which was the case we just did, Judge Middlebrooks denied what in New York legal parlance would be called a motion to re-argue, pursuant to which Donald Trump asked Judge Middlebrooks to vacate sanctions imposed on him and his legal team totaling close to $1 million. Judge Middlebrooks wrote on the first page thereof that movements acted in bad faith in bringing this lawsuit, and that this case exemplifies Mr. Trump's history of abusing the judicial process. Unfortunately, sanctions are the only way to impress upon defendants' attorneys that the consequences of engaging in repetitive, frivolous motion practice after this court, affirmed by the appellate division, expressly warned them against doing so. Whoa. It is of no consequence whether the arguments were made at the direction of the clients or sua sponte by the attorneys. Counsel are ethically obligated to withdraw any baseless or false claims, if not upon their own review of the record, certainly by the time the Supreme Court advised them of this fact. Oh, dear. And then we're citing Boyle, upholding sanctions against attorneys because counsel continued to pursue which were completely without merit in law or fact. Citing repetitive, meritless motions, affirming sanctions imposed on attorneys for repeated pattern of frivolous conduct. And then the Heller case, affirming sanctions against attorney upon finding there was no factual or legal basis for defendant's original cross motion or for the re-argument motion, that both motions were totally frivolous and were submitted just really to delay. Counsel should be the first line of defense against frivolous litigation. Accordingly, this court grants the AG's motion for sanctions, in part to the extent of sanctioning each of the defendant's attorneys who signed their name to the instant legal briefs. Oh my goodness. What? What? In the amount of $7,500 each to be paid to the lawyer's fund for client protection of the state of New York no later than 30 days from the date of this order. All right, let's bump down and see who got. Oh my gosh. Oh, this judge is so mad. The following attorneys signed their names to defendants' instant briefs and are accordingly sanctioned. Michael Madow, Clifford S. Robert, Esquire, Michael Farina, Christopher Kais, who was admitted pro hoc vice, and Armin Morium. Wow, each of them have been sanctioned. Arguments defendant raised for the first time. All right, so all of these were previous arguments that had no merits. So now the judge is saying, let's talk about arguments that they're raising for the first time. Oh, yay. Woohoo. Hello, everybody. Welcome, welcome. Summary judgment standard. So, to prevail on its motion for summary judgment on all causes of action, defendants must first make a prima facie showing of entitlement to judgment as a matter of law, tendering sufficient evidence to eliminate any material issues of fact from the case. Failure of the movement to make such showing requires denial of the motion, regardless of the sufficiency of the opposing papers. If the defendants make out their prima facie showing, the burden then shifts to the plaintiff to offer evidence sufficient to rebut that showing by identifying disputed issues of fact that should go before a trier of fact. Defendants strenuously argue throughout their briefs that the AG has not met her burden sufficient to defeat defendants' motion for summary judgment. However, defendants misstate the black letter law applicable to summary judgment. Whoa, you don't want to hear that from a judge. You really don't. That's bad news. All right. Citing to the City Dental case, for flatly the wrong proposition that in order to defeat summary judgment on these claims of predicate illegality, the New York AG must, with respect to each predicate illegality attached, establish each element of its cause with respect to those causes of action. Not only does City Dental not stand for the proposition, oh dear, it merely found that under the circumstances of that case, plaintiff's evidence failed to meet her burden on summary judgment. But the law is well settled that to defeat a motion for summary judgment, the opposing party must show facts sufficient to require a trial of any issue of fact, not make out its own case. So he's reiterating again that we're not here to retry a case with this motion for summary judgment, that we actually have a particular burden of proof needed and that the test needs to be met. While the AG must establish each and every element of its cause of action in order to prevail on its own motion for summary judgment, in order to defeat defendant's motion for summary judgment, provided defendants are able to demonstrate a prima facie case, an opposing party must show facts sufficient to require a trial of any issue of fact. And down here, so we've got this citing the Guzman case, evidentiary facts derived from documents submitted in opposition to summary judgment motion are sufficient to present a triable issue of fact. So let's get into the worthless clause. Now, many of you may have heard about the worthless clause, which has been used multiple times during his deposition, where he was saying that this particular clause, everybody just says, you know, whatever, it's a subjective situation. So let's get into the judge's debate there. Defendants rely on what they call a worthless clause set forth in the SFCs under the section entitled Basis of Presentation. That reads as here, pertinent as follows. All right, everybody ready for a moment of business law? Here we go. Assets are stated at their estimated current values and liabilities at their estimated current amounts using various valuation methods. Such valuation methods include, but are not limited to, the use of appraisals, capitalization of anticipated earnings, recent sales and offers, and estimates of current values as determined by Mr. Trump in conjunction with his associates and, in some instances, outside professionals. Considerable judgment is necessary to interpret market data and develop the related estimates of current value. Accordingly, the estimates presented herein are not necessarily indicative of the amount that could be realized upon the disposition of the assets or payment of the related liabilities. The use of different market assumptions and/or estimation methodologies may have a material effect on the estimated current value amounts. Okay, did everybody get that? Did everybody get what that meant? All right. In his sworn deposition, Donald Trump spent a lot of time invoking this clause. Quote, well, they call it a disclaimer. They call it a worthless clause too, because it makes the statement worthless. Donald Trump goes on to say, I have a clause in there that says, don't believe the statement, go out and do your own work. This statement is worthless. It means nothing. Furthermore, Donald Trump implies that he did not consider it important to review the SFCs for accuracy because of the existence of this purported worthless clause. So here we go with the deposition. The AG, does this refresh your recollection of the process whereby you would get final review of the statements of financial condition? Donald J. Trump, yeah, I think generally it's interesting. I would say as years went by, I got less and less. And then once I became president, I would, if I saw it at all, I'd see it, after it was already done. So in the period, again, I hate to be boring and tell you this, when you have the worthless clause on a piece of paper and literally the first page you're reading about how this is a worthless statement from the standpoint of you're using it as a bank or whatever, whoever may be using it, you tend not to get overly excited about it. I think it had very little impact, if any, on the banks. So am I understanding that you didn't particularly care about what was in the statement of financial condition? I didn't get involved in it very much. I felt it was a meaningless document, other than it was almost a list of my properties with a good faith effort of people trying to put some value down. It was a good faith effort. Goodness. Defendants further submit the affidavit and deposition transcript of Robert Unnell, who purports to be an expert in commercial real estate, for the proposition that because of the worthless clause in the SFC, no lender relies on these for what it is. However, defendants' reliance on these worthless disclaimers is worthless. What? Oh my gosh. I gotta highlight that one. That's a good one. The reliance is worthless. The clause does not use the word worthless or useless or ignore or disregard or any similar words. It does not say the values herein are what I think the properties will be worth in 10 or more years. Indeed, the quoted language uses the word current no less than 5 times and the word future 0 times. Whoa, this judge is pissed. Oh my gosh. Additionally, as discussed, a defendant may not rely on a disclaimer for misrepresentation of facts peculiarly within the defendant's knowledge. Here, as the valuations of the subject properties are obviously peculiarly within the defendant's knowledge, their reliance on them is to no avail. Furthermore, this special facts doctrine applies regardless of the level of sophistication of the parties. Ouch. Thus, the worthless clause does not say what the defendants say it says, does not rise to the level of an enforceable disclaimer, and cannot be used to insulate fraud as to facts peculiarly within defendant's knowledge, even vis-a-vis sophisticated recipients. I need sunscreen for the intensity of the judge's burn. Seriously, he's so pissed off. Oh my gosh. All right. Okay. So the worthless clause is a no-go, is what I'm getting from this judge. Oh, I have a hard time with my R's. You'll have to forgive me. I'm originally from Texas. It took me a long time to get rid of the twang, so I'm a little extra sensitive about it. Oh, goodness. All right, so the tolling agreement. So this is the reason why Ivanka then was released from this lawsuit, was because she was not a part of the tolling agreement, or else she would have been a part of the suit. The First Department has declared that claims are timely against defendants subject to the tolling agreement if they accrued before or after July 13th of 2014. And claims against defendants not subject to the tolling agreement are timely if they accrued after February 6th of 2016. Defendants concede that the tolling agreement binds each of the LLC defendants and the Trump Organization. However, they argue that each of the individual defendants and Donald J. Trump Revocable Trust are not bound by the agreement. Alan Garten, the Trump Organization's chief legal officer, originally entered into the tolling agreement on behalf of the Trump Organization on August 27th of 2021. The agreement was extended one time by an amendment dated May 3rd of 2022. It tolls the statute of limitations for a period from November 5th of 2020 through May 31st of 2022. The agreement contains a footnote to the entity, the Trump Organization, that reads as follows. All right, here we go. As noted in the December 7th of 2019 subpoena issued in this investigation to the Trump Organization, the Trump Organization as used herein includes the Trump Organization, Inc., DJT Holdings, LLC, DJT Holdings Management Member, LLC, watching from Australia. Oh, hello, welcome. And any predecessors, successors, present, or former parents, subsidiaries, and affiliates, whether direct or indirect, and all directors, officers, partners, employees, agents, contractors, consultants, representatives, and attorneys of the foregoing, and any other person associated with or acting on behalf of the foregoing or acting on behalf of any predecessors, successors, or affiliates of the foregoing. Whew, goodness, that was a lot. Thus, the tolling agreement at issue here binds all directors and officers and present or former parents of the Trump Organization and its affiliates and subsidiaries. It is undisputed that at the time the tolling agreement was executed, each individual defendant, Donald J. Trump, Donald Trump Jr., Eric Trump, Alan Weisselberg, and Jeffrey McConney, were all directors and or officers of the Trump Organization. Defendants argue that the non-signatory defendants are not bound by the agreement, citing this case. However, defendants fail to quote the following sentence, which provides that a non-signatory may be bound by a contract under certain limited circumstances. What you don't want is a judge quoting your case to you, quoting it back to you because you've quoted it incorrectly. That's what you don't want. That's what's happened here. So, non-signatory companies bound by agreement with language defining signatory to include all subsidiaries, affiliates, and successors. In the People v. Jewel Labs, in a case involving nearly identical language in a corporate tolling agreement, the First Department recently held that non-signatory corporate affiliates, officers, and directors were bound by the agreement. Similarly, here, all the individual defendants are bound by the instant tolling agreement terms and may be held liable for any claims that accrued after July 13th of 2014. All right. So, what's a tolling agreement? So there is always a statute of limitations that is put into place for any kind of a civil case. And if we have the toll has run, then you can't bring the civil lawsuit. But here, what they had was this agreement to pause the statute of limitations so that later they could bring the suit. So we didn't have a statute of limitations issue because there was this agreement. Why they made this agreement, I don't know. Maybe the judge will get into it, but this agreement was set out in such a way that made it so the lawsuit could be brought. And it looks like the defendants are trying to get out of it. It's taking a toll on you. Oh, can this judge's ruling be extended to other states like Florida? Well, Florida's already got their sanctions in. Florida already hit the ball back to New York. So, yes, all of these can be used. All of them. All of the sanction orders can be used. Defendants argue that the AG is judicially stopped from asserting that the agreement binds the individual defendants based on statements the AG's counsel made during oral arguments in the investigatory special proceedings. Specifically on April 25th, while seeking to hold Donald Trump in contempt for failing to comply with court orders. AG's counsel stated there is a hard prejudice because Donald Trump is not a party to the tolling agreement. That tolling agreement only applies to the Trump Organization. For judicial estoppel to be applicable, first, the party against whom the estoppel is asserted must have argued an inconsistent position in a prior proceeding, and second, the prior inconsistent position must have been adopted by the court in some manner. Defendants are correct that the first prong is satisfied in that the statements the AG's counsel made during oral arguments are inconsistent with the position AG is now taking. However, defendants cannot demonstrate that this court adopted the prior position. Indeed, this court did not need to and did not consider the tolling agreement when it issued its April 26th decision. So the estoppel just means like 2 bites of the apple. So something that's already been determined. So he's trying to say in a previous order, you already made this determination that I was out, that I wasn't part of this tolling agreement, so I shouldn't be included. And the judge is saying, no, I didn't make that decision. So no. This court has not addressed the tolling agreement until now. Accordingly, defendants cannot demonstrate that this court adopted AG's prior inconsistent position. Fair enough. That's up to the judge. It's up to the judge to decide. Moreover, the party asserting estoppel must show with respect to himself a lack of knowledge of the true facts, 2, reliance upon the conduct of the party estopped, and 3, a prejudicial change in his position. Here, none of the defendants claim that they changed their position or courses of conduct in reliance upon the statement of AG's counsel during oral argument. Finally, while judicial estoppel may be applied to prohibit inconsistent changes in factual positions, courts have declined to extend the doctrine to changes in legal positions. So, who physically signed the agreement is a question of fact. Whom it binds is a question of law. Defendant's argument that the DJT revocable trust is not bound by the tolling agreement, falls flat. In his deposition, Donald Trump affirmed under oath that the assets of the Trump Organization are held in the DJT revocable trust, for which he's the sole donor and beneficiary. Donald Trump also affirmed that at the time the trust was formed, he was the sole trustee and remained the sole trustee until 2017, when the defendants, Alan Weisselberg and Donald Trump Jr., became sole trustees. As every beneficiary, donor, and trustee of DJT Revocable Trust is a defendant bound by the tolling agreement, and as the trust is unquestionably a parent of the Trump Organization, so too does the tolling agreement bind the DJT Revocable Trust. Okay, one moment, please. I need to pause to hydrate for just one moment, so please bear with me. Whew, okay, and we're back. Yes, have to hydrate. All right, so here we go. We've got the revocable sheer madness. Yes. Oh, I love it. I love it. All right, here we go. It may likewise be inferred that the trustees had knowledge of the activities of the businesses they controlled through the trust mechanism. Hence, under Executive Law 6312, the family trusts and trustees may likewise be held liable for the fraud. Yikes. Defendants cite the New York Estates Power and Trust Law 11-1 for the proposition that only a trustee may bind a trust to an agreement. However, that section does not state this. Rather, I love it when he keeps saying that the law that they're using is wrong. That's, I think, my favorite part. Rather, it states, B, in the absence of contrary or limiting provisions in the court order or decree appointing a fiduciary, or in a subsequent order or decree, or in the will, deed, or other instrument, every fiduciary is authorized to execute and deliver agreements, assignments, bills of sale, contracts, deeds, notes, receipts, and any other instrument necessary or appropriate for the administration of the estate or trust. This provision simply says what a fiduciary is permitted to do in the absence of a contrary provision. It does nothing to advance defendant's argument that only a trustee may bind a trust. That's pretty significant. Yikes. Particularly since defendants failed to cite any provision of the DJT Revocable Trust restricting who can bind it, as 11-1 anticipates. Moreover, Korn v. Korn, upon which defendants inexplicably can he appeal summary judgment? Sure. But he's appealing to the second division, the first division, and the first division's already had this case over and over and over again. So they're pretty familiar with this situation. Inexplicably rely is irrelevant to the instant analysis, as that case involved an examination by the court as to whether a fiduciary had a right or duty to negotiate on behalf of an estate pursuant to 11-1, not pursuant to 11-1B17, to which the defendants cite. So he's saying you're using the wrong law again. Finally, the Attorney General should not be limited in her duty to protect the public interest by an agreement she did not join. Attorney General not bound by arbitration agreement when pursuing Executive Law 6312, claim and finding such an arrangement between private parties cannot alter the Attorney General's statutory role or the remedies that she is empowered to seek. The tolling agreement was a mutually beneficial and common arrangement pursuant to which OAG agreed to hold off suing, and Alan Garten, on behalf of the Trump Organization, agreed to toll the statute of limitations. All defendants received the benefit of the bargain. The OAG held off suing. The OAG is entitled to its benefit of the bargain. The tolling of the statute of limitations for the limited agreed upon time, as against anyone it could have sued for that matter at issue at the time at which the agreement was executed. The AG clearly did not intend to permit defendants' principals to evade the tolling agreement based on a technicality contrary to the spirit of the agreement and controlling case law. Whoa, that's pretty serious. All right, statute of limitations. As a general rule, statutes of limitations start running when a claim accrues. That is, when it can be sued upon. In arguing that the AG's causes of action are untimely, defendants incorrectly assert that the statute of limitations starts running on the date the parties entered into the subject agreements or when the loans closed. However, the First Department did not use the word closed. It used the words completed. Obviously, the transactions were not completed, while the defendants were still obligated to and did annually submit current SFCs to comply with the terms of the loan agreements. Defendants further assert that any continuing documentation provided after the agreements were entered into and or when the loan closed is of no consequence if the proceeds were distributed prior to July of 2014. This argument is unavailing. As the AG asserts, each submission of the SFC after July 13th of 2014 constituted a separate fraudulent act. Indeed, each submission of a financial document to a third-party lender or insurer would require a separate exercise of judgment and authority, triggering a new claim. Defendants mistakenly assert that if a loan agreement was entered into and its proceeds were dispersed prior to the applicable statute of limitations, then a claim arising out of submitting any subsequent contractually required financial documentation is also untimely, irrespective of when the documentation was submitted. Defendants would have this court apply a bizarre, inverted form of the relation back doctrine, pursuant to which, if one aspect of fraudulent, they're not lawyers, but it's possible. I would say at this point, although I don't know, they're going to get sanctioned again. Business conduct falls outside of the statute of limitations, then all subsequent aspects of fraudulent conduct also fall outside the statute, no matter how inextricably intertwined. So he's saying your argument's bad, is what the judge is saying there. Of course, this is contrary to controlling case law, which holds that a cause of action accrues at the time when one misrepresents a material fact. Moreover, even in the plain language of the executive law of Section 6312 states, the term repeated as used herein shall include repetition of any separate and distinct fraudulent or illegal act. What does sanctioned mean? It means that they were found to be filing certain motions or doing certain actions in bad faith towards the courts, and so they were fined. So part of this order is a sanction to all of the attorneys that had signed on to the brief that was involved in this case. So clearly, the submission of each separate fraudulent SFC is a distinct fraudulent act. The AG is not challenging the loans, the closings, or the disbursements. It's challenging defendants' submissions of financial documents containing false and misleading information. Thus, any SFC that were submitted after July 13th of 2014 falls within the applicable statute of limitations. Materiality. We got to have that. It is settled that a standalone cause of action under Executive Law 6312 does not require a demonstration of materiality, but merely that an act has the capacity or tendency to deceive or create an atmosphere conducive to fraud. Although the Domino's Court found that evidence regarding falsity, materiality, reliance, and causation plainly is relevant to determining whether the AG has established that the challenged conduct has the capacity or tendency to deceive, or creates an atmosphere conducive to fraud, every appellate division and the New York Court of Appeals now hold that materiality and scienter are not requirements for liability under Section 63, scienter meaning intent. However, as discussed, although materiality is required under the 2nd through 7th causes of action, it's not required under a standalone cause of action under Executive Law 6312, the AG's first cause of action. Defendants argue that the SFCs were not materially misleading, claiming, so in other words, the information that they gave about the worth, they're saying were not misleading. 1, there's no such thing as objective value. 2, a substantial difference between valuation of the SOFCs and appraisal per se is not evidence of inflated value. 3, there's nothing improper about using fixed assets valuation as opposed to using the current market valuation approach. Wow. And 4, it's proper to include internally developed intangibles such as brand premium used in the valuation of President Trump's golf clubs. What? In personal financial statements. What? His golf clubs? Wait, hold on. Wait a minute. What just happened here? It was proper to include internally developed intangibles such as brand premium used in the valuation of President Trump's golf clubs in personal financial statements. The golf clubs were worth more because they were Trump's golf clubs. Okay. All right. Yeah, the brand. Remember the brand? The brand is worth $2.2 billion compared to everything else. Like, what? Yeah. Okay. Right. Not the clubs, not the golf clubs you play with, but the clubs you go and visit. Okay. We got you now. Thus, defendants essentially argue that value is inherently subjective, that because internal brand valuations are in the eye of the beholder. Here, Donald Trump, they cannot be overvalued. Defendant argues that no bank or underwriter would have reasonably been materially misled by the alleged misstatements or omissions in the SOFCs and other information that the defendants made available to their counterparties, because no sophisticated counterparty would have considered the SOFCs and other information provided by the defendant alone as material to extend credit or set an interest rate or issue an insurance policy or price a risk without doing their own due diligence. Yeah, that's a lot. Defendants also argue it follows that if the user of the SFCs is in possession of the correct information, then the financial statements are not materially misstated. Oh, no. Defendant's stance is, practically speaking, that they may submit false SFCs so long as the recipients know from their own due diligence that the information is false. I don't think that's how that works. I mean, I'm not a business law attorney, but I don't think that's right. It's the bank's fault they didn't check our phony numbers. Well, yeah, I don't think that's how that works. All right. Accepting defendant's premise would require ignoring decades of controlling authority, holding that financial statements and real property valuations are to be judged objectively, not subjectively. That's kind of important. Moreover, courts have long found that generally it's the market value which provides the most reliable valuation for assessment purposes. All right. Further, defendants assertion that the discrepancies between their valuations and the OAGs are immaterial is nonsense. The AG has established in many cases by clear, indisputable documentary evidence, as discussed, is not a matter of rounding errors or reasonable experts disagreeing. AG has submitted conclusive evidence that between 2014 and 2021, defendants overvalued the assets reported in the SFCs between 17.27 to 38.51%. Whoa. This amounts to a discrepancy between $812 million and $2.2 billion. Whoa, that's a lot. That's a lot. Let's just highlight those numbers here so we don't forget. Wow, 812 million to 2.2 billion dollars. Yikes. That's a lot. That's a lot. Even in the world of high finance, this court cannot endorse a proposition that finds a misstatement of at least $812 million to be immaterial. Defendants have failed to identify any authority for the notion that discrepancies of the magnitude demonstrated here could be considered immaterial. Wow, that's a lot. Yeah, that's a lot. 812 million. And that's the low end, right? Yeah, that's a lot. That's a big discrepancy. Again, I'm no business lawyer here, but it seems like a lot. The second through seventh causes of action. The second, third, fourth, fifth, sixth, and seventh causes of action allege violations of Executive Law 6312 based on underlying violations of the New York Penal Law prohibiting falsification of business records, issuance of false financial statements, and insurance fraud. Liability under New York Penal Law, Section 175.04, falsifying business records in the second degree, requires that a person makes or causes a false entry in business records of an enterprise. Liability under Section 175.45, issuing a false financial statement, requires that a person represents in writing that a written instrument purportedly to describe a person's financial condition or ability to pay as of a prior date is accurate with respect to such person's current financial condition or ability to pay, whereas that person knows it's materially inaccurate in that respect. Liability under New York Law Section 176.05, insurance fraud, requires that a person submitted an application for an insurance, either knowing that it contained materially false information concerning any fact material thereto, or two, concealed for the purpose of misleading information concerning any fact material thereto. Accordingly, unlike the standalone cause of action under Executive Law 6312, the second through seven causes of action require demonstrating some component of intent and materiality. AG has demonstrated that there remain, at the very least, disputed issues of fact as to whether the defendants violated these statutes intentionally or materially. Thus, there are issues of fact to causes of actions 2 through 7 that require a trial. All right, so this is that second part of the motion for summary judgment. So counts 2 through 7 regarding intentional fraud, insurance fraud, those issues need to be tracked in front of a trial. So they need to have a fact finding situation. So for count 1, the judge is deciding in favor of the state, but for counts 2 through 7, they are going to need to go forward with a trial, which again is set for Monday to start. The court has considered defendants' remaining arguments and finds them to be unavailing and or non-dispositive. Accordingly, defendants' motion for summary judgment dismissing every cause of action is denied in its entirety. So defendants' motion for summary judgment, the art of the plea deal. Oh my goodness. All right. So defendant's motion is done, and we've got then the judge is putting now into his order what we have for cause number 1. So the first piece, the AG's motion for partial summary judgment on its first cause of action. Summary judgment burden on standalone Executive Law 6312 cause of action. The AG moves for partial summary judgment. Are the banks going to ask for their money back? I think we still got a trial. Going on. So we'll probably want to put it all together into one big pot. The AG moves for partial summary judgment, seeking to hold defendants liable under the AG's first cause of action for fraud under Executive Law 6312. As this court has noted as nauseam, I'm not sure is that Latin? Nauseam. Oh, that's so funny. Executive Law 6312 authorizes the Attorney General to bring special proceeding against any person or business that engages in repeated or persistent fraudulent or illegal conduct, while broadly construing the definition of fraud so as to include acts characterized as dishonest or misleading and eliminating the necessity for proof of intent to defraud. The AG's first cause of action, the only one upon which it moves for summary judgment, so the state didn't even move for summary judgment on 2 through 7, just FYI, alleges a standalone violation of Executive Law 6312. The AG need only prove that the SFC were false and misleading, and defendants repeatedly or persistently used SFCs to transact business. This instant action is essentially a documents case. As detailed, the documents here clearly contain fraudulent valuations that defendants used in business, satisfying the AG's burdens to establish liability as a matter of law against defendants. Defendants respond that the documents do not say what they say, and there is no such thing as objective value, and that essentially the court should not believe its own eyes. What? Don't believe your own eyes, court. Let's bump down. Okay, as Chico Marx playing Ciccolini says to Margaret Dumont playing Miss Gloria Teaswell, duck soup, well, who you going to believe, me or your own eyes? What? He's not allowed to have legal control of some of his New York business. Yeah, I mean, some of it, but we'll continue on. Once he continues to go through his motion for summary judgment, he'll explain further what the different pieces are to it. So the defenses Donald Trump attempts to articulate in his sworn deposition are wholly without basis in law or fact. He claims that if the values of the property have gone up in the years since the SFCs were submitted, then the numbers were not inflated at the time. But you take the 2014 statement, if something is much more valuable now, or I guess we'll have to pick a date, which was a little short now. But if something is much more valuable now, then the number that I have down here is low. What does that even mean? What is that? I don't know what that means. He also seems to imply that the numbers cannot be inflated because he could find a buyer from Saudi Arabia to pay any price he suggests. What? Oh my goodness. This statement may suggest influence buying more than savvy investing. Oh dear, that's not nice. Oh my goodness. All right, let's look at the Trump Tower triplex. This court takes judicial notice that the Trump Tower apartment in which Donald Trump resided for decades, the triplex, is 10,996 square feet. Between 2012 and 2016, Trump submitted SFCs falsely claiming that the triplex was 30,000 square feet, resulting in an overvaluation of between 114 to $207 million. Whoa, that's a lot. The misrepresentation continued even after defendants received written notification from Forbes that Donald Trump had been overestimating the square footage of his triplex by a factor of 3. Whoa. 3 days after receiving a written inquiry from Forbes, Trump Organization Vice President Amanda Miller sent an email to Trump Organization's Executive Vice President and Chief Legal Officer Alan Garten, indicated that she spoke with Alan Weisselberg regarding Trump World Tower and Trump Tower, and we're going to leave those alone. Although the OAG need not show intent to deceive under standalone 6312 cause of action, this directive to continue to use a grossly inflated number despite clear knowledge it is false demonstrates the repetitive and ongoing nature of the defendant's propensity to engage in fraud. Ouch. In opposition, defendants absurdly suggest that the calculation of square footage is a subjective process that could lead to different results or opinions based on the method employed to conduct the calculation. Wait, that's not how you do square feet? What? What is that? I can't. Despite their assertion in their motion papers, counsel for defendant Christopher Kise concluded during oral argument held on September 22nd of 2023 that square footage is, in fact, an objective number. What? This is crazy. Well, yes, perhaps if the area is rounded or oddly shaped, it's possible measurements for square footage could come to slightly differing results due to user error. Good faith measurements could vary as much as 10 to 20%, not 200%. Oh my goodness. Oh my goodness. A discrepancy of this order of magnitude by a real estate developer sizing up his own living space of decades can only be considered fraud. Ouch! Oh my gosh. In fact, the AG demonstrates that as of 2012, no apartment sold in New York City had ever approached the price at which defendant valued the triplex, noting that the highest overall sale at the time was $88 million for a Central Park West penthouse. The SFC's value the triplex at a staggering $180 million to $327 million for the years 2012 to 2016. Goodness gracious, that's a lot. The OAG unquestionably satisfies its two-pronged burden of demonstrating the SFCs from 2012 to 16 calculated the value of the triplex based on false and misleading square footage, and that some of the defendants repeatedly and persistently used the SFC to transact business. Seven Springs Estates. Wow. Defendant Seven Springs LLC owns over 200 acres of contiguous land in the towers of Bedford, Newcastle, and North Castle in Westchester County, New York. He used gilded mirrors to make up the space. It looks so much bigger because of the mirrors, right? That's understandable. Yeah, height and weight. I don't know. I mean, I'm not a real estate lawyer, but that didn't sound right to me. In 2000, not one non-party, the Royal Bank of Pennsylvania, appraised the as-is market value of Seven Springs at $25 million if converted to residential developments. In 2006, the same bank performed a new appraisal, which showed Seven Springs had an as-is market value at $30 million. He just had to think it, and then it was true. So true. In 2012, Seven Spring received another appraisal that estimated a 6-lot subdivision on Newcastle portion of the property to have a fair market value of approximately $700,000 per lot. In July of 2014, because the Trump Organization was considering donating a conservation easement, it retained Cushman and Wakefield to provide a range of value of the Seven Springs property. Cushman and Wakefield's appraiser, Mr. Ardle, analyzed the sale of the 8 lots in Bedford, 6 lots in Newcastle, and 10 lots in North Castle, and determined the fair market value of all 24 lots was approximately $30 million. Can you pin this? If Trump and others will need to appeal. Yeah, they can. They can appeal. They can appeal any of it. Absolutely, they can. So here we go. They had, $30 million, notwithstanding receiving market values from professional appraisals in 2000, 2006, 2012, and 2014, valuing Seven Springs at or below $30 million. Donald Trump's 2011 SFC reported the value at $261 million. Wow, that's a lot more than $30 million. That's quite a bit more. Appeal's good to know. Yeah, sorry, I'm trying to plug away here. All right, so we have an overestimation here. 30 million, 261, 291. All right, that's an overestimation. Will Trump and family have to... Okay, that says appeal, right? Appeal? They can. Appear. Do they have to appear? Emily, I'm sorry, forgive me. Do they have to appear? So, this trial that's going on, I would assume they would need to come to court, but it's a civil trial, and we'll see. I'm interested to see if the court will order them to show up or not. Appear. Yes, sorry about that. My bad. My bad. Sorry. The smoke and mirrors defense. Yeah, I'm not sure. I'm gonna wait and see because he could put that into his order here. Oh, you're so welcome. Sorry, I'm a little little dense. All right. In early of 2016, Cushman and Rakeville performed another appraisal of Seven Springs, which included the planned development and determined that as of December 1st of 2015, the entire parcel was worth $56.6 million. So nowhere near that 200 million number. Even giving defendants benefit of the doubt, the 56.6 million figure as December 1st of 2015, the value submitted on Trump's 2014 SFC was inflated by over 400%. Accordingly, the AG has demonstrated liability for the false 2014 SFC for fraudulently inflating the value of Seven Springs. All right, Trump Park Avenue. Trump Park Avenue is a residential building included as an asset in Trump's SFCs for the years 2011 to 2021. In 2011, 12 of the unsold residential condominium units were subject to New York City's rent regulation laws. By 2014, 9 units remained subject to rent restrictions. By 2020, 6 units remained subject to rent restrictions. In 2010, appraisal performed by the Oxford Group valued 12 rent-stabilized units, $750,000 total, or $62,500 per unit. A 2020 appraisal performed by Newmark Knight Frank valued 6 units that remained subject to stabilization at $22,800,090 total, or $3,800,000 per unit. Notwithstanding, for the years 2014 to 2021, Trump organizations submitted SFCs and valued these rent-restricted units as if they were unencumbered, inflating the value of each unit between as much as 700%, whoa, in 2014 and 64% in 2021. In an unsuccessful attempt to rebut AG's prima facie demonstration, defendants proffer that the units are not overvalued because the rent-stabilized units have the potential at some point in the future to be converted into unencumbered by rent stabilization units. They further concede that this is the assumption the owner made when assessing potential asset pricings or value. Wow. As every New Yorker knows, rent-regulated units may be passed on from one generation to the next in perpetuity. What? That argument wasn't as strong as they had hoped, I guess. Yikes. All right, here we go. So, however, excuse my ignorance, but what's an SFC? So this is the regulation. Let me give you the exact definition here. I'm looking at it as one of the regulatory documents that needs to be figured. So let me just pull up. Yeah, securities and let me just make sure. Real, okay. Oh. We needed a ton more rent control. Yeah, true story. Statement of financial condition. Thank you. Yep, I had the wrong thing. So this all has to do with the information he included regarding how much he had valued each piece. So it's basically a document that was set in there. Thank you, Dino. Appreciate that. Yeah, statement of financial condition. So every time you see SFC, this is a report he prepared and put together with his own knowledge of information regarding his stuff. And it was correct. And it was incorrect. Statement of financial conflations. Yes. So this is it. I mean, these that he filed all of these years were completely inflated. All right, here we go. So 40 Wall Street. The Trump Organization, through defendant 40 Wall Street, owns a ground lease, 40 Wall Street, and pays ground rent to the landowner. In 2010, Cushman & Wakefield appraised the Trump Organization's interest at $200 million. Again, in 2011 and 2012, it was 200 to 220 million. The Trump Organization possessed and was familiar with these appraisals. Despite these appraisals, the 2011 and 2012 SF's statement of fantasy conditions. So his financial statement valued the Trump Organization's interest in the property at $524.7 million. What? That's statement of financial con. Oh my gosh. Yeah, it might be a gold mine. That's a lot. That's a really big number compared to 200. That's a lot. 215, once again, appraised the property. Its value, once again, appraised the property and valued it at $450 million. Notwithstanding this appraised value, the 2015 SFC listed the value at $735.4 million. Wow, that's a significant jump. That's a lot. So we've got some significant discrepancies in our numbers, the judge is saying here. Defendants assert that overvaluations of $200 million are immaterial, as the New York AG has produced no evidence to suggest the latter capital would have been uncomfortable allowing President Trump to guarantee the 40 Wall Street loan if his net worth was only $1.9 billion, as the New York AG contends. They further emphasize that the latter capital has received in excess of $40 million in interest, and 40 Wall Street has never defaulted on a loan. Defendants' argument misses the mark, as has been explained to defendants many times in many legal proceedings and in painstaking detail. What? This judge? And in painstaking detail. Whereas here, there's a claim based on fraudulent activity under Executive Law 6312, disgorgement may be available as an equitable remedy, notwithstanding the absence of loss to individuals or independent claims for restitution. So he's saying again, Trump was saying there's no harm that's been done, and the judge is saying it doesn't matter. The harm isn't needed. It's the intent and the action, and you did it. Oh my gosh. Go back on the last page and read Mars. Oh, did I miss a piece? Hold on. Here we go. We got it. We'll go backwards. Mazars' accountant, Donald Bender, testified that when he asked Jeffrey McConnell, do you have any other appraisals? Jeffrey McConnell stated, I have nothing else, demonstrating an intent to conceal or mislead the accountants. All right. Further, Patrick Bain of the Trump Organization employee worked directly under McConney, conceded that the Trump Organization maintained a spreadsheet for day-to-day operations on the Trump Park Avenue offering plan that included both the offering plan prices and the current market values, but that the Trump Organization concealed its own actual market estimates from Mazars by omitting the market value column in its spreadsheet and providing Mazars with only the offering plan prices. What? Who does that? That's awful. What? Oh my goodness. What? So we just don't include the column? Is that what we're doing here? Oh my goodness. All right. And then there's more discussion here. An email exchange between Weisselberg and his son discusses in 2015 $540 million, notwithstanding direct knowledge of it, nearly a $200 million more. Oh my gosh. I bet they could tell a column was missing too. Right, Tiffany? Right. They're like, wait a minute. I think something's missing. Why didn't they sort that out? Oh my gosh. Okay. Here we go. You got to keep going. So here we go. We've missed the mark, and we have been giving painstaking detail there. So liability has been demonstrated, so that piece is okay. Mar-a-Lago. Donald Trump purchased Mar-a-Lago. Uh-oh, what's going to happen with Mar-a-Lago? I'm worried now. Donald Trump purchased Mar-a-Lago in 1985. In 1993, he sought and obtained permission from the town of Palm Beach to turn the property into a social club. On August 10th of 1993, he entered into a declaration of use agreement by which he agreed to use the land shall be for a private social club, and that any additional use of the land shall be subject to approval by applicable governmental authority, including but not limited to the town council of the town, the Landmarks Preservation Commission of the town, and the Architectural Review Commission of the town, Palm Beach County, the state of Florida, the United States governor, and or any agencies under the foregoing government authorities. All right. In 1995, he signed the Deed of Conservation and Preservation easement in which he gave up his right to use Mar-a-Lago for any purpose other than as a social club. In 2002, Trump signed a deed of development rights as part of granting a conversation easement to the National, I don't know, I'm worried, Trust for Historic Preservation. Donald Trump agreed that Trump intended to forever extinguish his right to develop or use the property for any purpose other than club use. The 2002 deed. The 2002 deed also specifically limits changes to the property, including without limitation the division or subdivision of the property for any purpose, including use as a single-family home, the interior renovation of the mansion, which may be necessary and desirable for the sale of the property as a single-family residential estate, the construction of new buildings, and the obstruction of open vistas. In exchange for granting the easement, Mar-a-Lago was taxed at a significantly lower rate, the club rate, than it otherwise would have been the private home rate. From 2011 to 2021, the Palm Beach County Assessor appraised the market value at between $18 million and $27.6 million. Notwithstanding, the SFC's values, so his financial statements values, do not reflect the land use restrictions. Trump's SFC between 2011 and 21 value Mar-a-Lago between $426 million, $529,614 million, and $612 million, an overestimation of at least 2.300% compared to the assessor's appraisal. Whoa, look at that. So they're saying it's 18 to 27, and he's saying it's 426 million to 612 million. That's a lot. Hydrate. Yes, I do need to hydrate. What is even that? Oh my gosh. That's wow. Is this because of the buyer from Saudi Arabia? 2,300%. Yes, thank you. Sorry, that's a comma, not a period. Thank you. That's a lot. Yeah. In an attempt to rebut the AG's demonstration, defendants rely on the opinion affidavit of Lawrence Moans, who they purport is the most accomplished and knowledgeable ultra-high net worth real estate broker in Palm Beach, Florida. That's right. The marble bathroom for the documents. It does. It really adds. It adds a lot. Moans claimed that the SOFC were and are appropriate and indeed conservative. What? The Moans affidavit states in a conclusory fashion that because he believes this unique property offers an elite purchaser an unparalleled opportunity to own an exclusive and extensive family compound in the most desirable sections of Palm Beach, the valuations of the SOFC were reasonable and below my estimate of the market value of the property each year. Moreover, Moans opines that if Mar-a-Lago was available for sale, I'm confident that in short order, I would be in a position to produce a ready, willing, and able buyer who would have interest in securing the property for their personal use as a residence or even their own club. Critically, Moens does not opine at what price he's confident he would be able to find a buyer, although he opines separately without relying on any objective evidence that he believes that as of 2023, the property is worth over $1.51 billion. What? What? It's well settled that where the experts' ultimate assertions are speculative or unsupported by any evidentiary foundation, however, the opinion should be given no probative force as is insufficient to withstand summary judgment. Oh my goodness. Okay, and then one endnote here. At oral argument, his domain of expertise was enlarged to a nationwide status. Oh my gosh. And then we have an endnote here on the $1.51 billion. In his sworn deposition, when asked, who were the dozen or so qualified buyers that you were referencing in your report, Lawrence Moens replied, I could dream up anyone from Elon Musk to Bill Gates and everyone in between. Kings, emperors, heads of states, but the net worth in the multiple billion dollars. I didn't know how many people in the world have a net worth more than $10 billion, but I think it's quite a number. There are a lot. Obviously, this court cannot consider an expert affidavit that's based on unexplained and unsubstantiated dreams. What? Jesus could come down and buy it. Jesus is not going to buy Mar-a-Lago. What? Oh my goodness. Oh my gosh, this is crazy. This is legal stuff, man. You can't go into a deposition and say, well, whatever. You can't do that. They don't like that. Judges really don't like that. Accordingly, defendant's reliance on the Moens affidavit is unpersuasive and certainly insufficient to rebut the OAG's prima facie case. You used to pull some gold bars out of your pockets. Oh my gosh, that's hilarious. All right. Defendants further imply that they may ignore the plain language of the 2002 deed restrictions because they would likely be able to use the Florida judicial system to get out of their contractual requirements. You're not supposed to say that. They further assert that because they may successfully breach their contract in the future, they were not required to consider restrictions of the 2002 deed when valuing the property. This argument is wholly without merit. At the time in which the defendants submitted the SFCs, the restrictions were in effect, and any valuations represented to third parties must have incorporated those restrictions. Failure to do so is fraud. Wow, the judge's not even playing around here. Assets values that disregard applicable legal restrictions are by definition materially false and misleading. Accordingly, the AG has demonstrated liability for the false valuation of Mar-a-Lago as appears in the SFCs from 2014 to 2021. Okay, Aberdeen. Am I saying that name right? I'm hoping I'm saying it right. Aberdeen. The Trump Organization owns a golf course located in Aberdeen, Scotland. The value assigned to Aberdeen was comprised of two parts, a value for the golf course and a value for the development of the non-golf course property, the latter of which is the focus here. Developing any of the non-golf course property required that the local Scottish authorities approved any proposed plans. From 2011 to 2014, Trump's SFC reported that he had received outline planning permission from local Scottish authorities. In December of 2008, for a residential village consisting of 950 holiday homes, oh, that's a lot, and 500 single-family residencies and 36 golf villas. The Trump Organization had outline planning permission to build a total of 1,486 homes, notwithstanding the 2014 to 2018 SFC's valuation of Aberdeen assumed the Trump Organization had received approval to build 2,500 homes, despite never having received such approval. Wow, that's a big deal. That's a really big deal. Additionally, the approval of the 950 holiday homes and 36 golf villas came with severe restrictions on their use. They could be used solely as rental properties and could be rented for no more than 12 weeks in any calendar year. The Trump Organization submitted financial documentations to the local Scottish authorities representing these short-term rentals would not be profitable and therefore would not add any value to Aberdeen. Consequently, the only profitable development of Aberdeen would have been the 500 single-family units. In July of 2017, non-party Ryden LLP, acting on behalf of the Trump Organization, prepared a development appraisal for the Aberdeen wherein it assessed the profit from developing 557 homes and estimated profits in the range of £16 million to £18 million. All right. What's going to happen? What's going to happen in Scotland? I'm worried. In May of 2018, the Trump Organization applied to the Aberdeen City Council to reduce the scope of the development project to 550 dwellings. This rule schmooze legal defense. No, it's not. Although you wouldn't know it, really. Apparently, you can just say anything in any of these pleadings at any time. Okay. 550 dwellings consisting of 500 private residents, 50 leisure resort units, and 0 holiday homes, having determined they were not profitable. In September of 2019, the Aberdeen City Council approved of the proposal for a reduction in the proposed development, but restricted the 50 leisure resort units as they had the holiday homes to be occupied on a holiday letting or fractional ownership basis only and for no other purposes whatsoever, including use as permanent residence unit. Notwithstanding the 2019 SFC finalized a month after the latest approval, derived a value based on the assumption that 2,035 private residential homes could be developed. Adjusting the values to reflect permissible 500 private residency reduces the value of Aberdeen undeveloped property as to reflect in the 2019 FSC £164,196. Although the defendants wholly failed to address Aberdeen in any of the 3 memos of law, in their response to the AG's statement of material facts, they state that defendants dispute the veracity of the appraisal because President Trump, as a land developer, took optimistic views of potential future value, which is not contemplated in the appraisal, thereby undervaluing Trump Aberdeen. For the reasons discussed, this defense fails. This judge is like, I'm not even getting into it. You're done. That one's not going to go. Accordingly, the AG has demonstrated liability for the false valuation of Aberdeen as appears in the SFCs from 2014 to 2019. All right. U.S. golf clubs. Donald Trump owns and leases a number of golf clubs across the United States and abroad that are included as assets in his SFCs. The value for these golf clubs is provided in the aggregate in the SFCs, although supporting accounting spreadsheets evidence the breakdown of the values assigned to each club. The Trump brand premium. All right, this is going to be good, everybody. We're going to see how much is the brand worth. We're looking at premium here. It's priceless, the brand. The evidence indicates that for years of 2013 to 2020, the SFC relied on the values that included a 15 to 30% premium based on the Trump brand for following 7 golf clubs: Trump National Golf Course, Jupiter, this one, this one, this one, this one, this one, and this one. However, the SFCs, hydrate. Okay, one moment. Hydrating. We're coming down to the end of it. I'm just like, what's he gonna say? Okay, here we go. However, the SFCs for those years, and indeed all the years before this court, also contain express language stating the goodwill attached to the Trump name has significant value that has not been reflected in the preparation of this financial statement. Accordingly, The SFCs double dip, both purporting not to include a brand premium while simultaneously including one of 15% to 30%. That's a lot. Doesn't Trump brand have a worthless clause? What? That's the best question of the night. Best question. Oh my goodness gracious. In opposition, defendants submit the affidavit of Eli Bartov, an accounting professor at New York University, who distinguishes between overall brand value and brand value ascribed to individual golf courses. His point, ensconced in numerous lines of academic jargon, I don't think the judge is impressed with the expert here, seems to be that the defendants said that they were eschewing the former and opting only for the latter. This is a red herring and factually incorrect. Did we just read something was a red herring? Oh my goodness. Oh my goodness. You really don't want a judge to say something's a red herring. That's never a good sign. Never. Never ever. Things are not going your way. Clearly state they do not include the brand value for any of the properties included in the SFCs. Indeed, the SFCs emphatically declare that the goodwill attached to the Trump name has significant financial value that has not been reflected in the preparation of this financial statement. Perhaps Donald Trump could have ascribed a brand value to golf courses that he viewed as special, but he was obligated to disclose those exceptions when he represented that the SFCs did not reflect his brand value. Oh my goodness. All right, let's take a look here at the Briarcliff in LA. The valuations of the TNGC Briarcliff and LA were each comprised of a value for the golf course and a value for the undeveloped land, as Trump Organization was considering donating a conservation easement over both properties. They had both properties appraised. In April of 2014, appraisal value of the golf club portion of the Briarcliff at $16 million. Later that same year, Donald Trump valued the golf club portion at $73 million. Wow, that's a big difference, isn't it? An inflation of more than 300% in his SFC. The 2015 appraisal valued the golf club portion in LA at $16 million as of December 26th of 2014. And 2015 SFC valued the golf club portion at $56 million, an inflation of more than 200%. Yikes. In an attempt to rebut this strong showing of fraud, the judge is like, oh my gosh. Defendants argue that they are not obligated to use market value, but instead were permitted to use fixed assets approach to valuation, pursuant to which defendants may value a property by aggregating the money spent to acquire and maintain the property. They further rely on the Bartov affidavit, which states, in wholly conclusory fashion, the assertion that using fixed assets approach does not present the golf clubs at their estimated current value because the approach ignores market conditions and behavior of informed buyers and sellers in unsubstantiated and false. Bartov is incorrect. This judge is not even playing. So that's wrong. Each of the corresponding SFCs include representations that assets are started at their estimated current values. Accordingly, it's false and misleading to use a fixed asset evaluation, which is completely different. The price for which you purchase the property is not necessarily the price for which you can sell it. The latter, not the former, makes the lenders who want adequate collateral. Oh my gosh. The membership liabilities. As part of the purchase of several of the golf club properties, Trump agreed to assume the obligation to pay back refundable non-interest-bearing long-term membership deposits. However, notwithstanding that these liabilities must be satisfied in the future, the SFCs from 2012 to 2021 value them at $0. Oh no, I'm worried now. This is false. They are a liability in the millions of dollars. What? liability in the millions of dollars. So that's different than zero. That's, oh my gosh. However, the SFCs all state the fact that Mr. Trump will have the use of these funds for that period without cost, and that the source of repayment will most likely be a replacement membership, has led him to value this liability at zero. Although it was false to report the membership liabilities as zero, it was not, under the circumstances, misleading, as the SFC states that the reason for doing. Accordingly, the AG cannot prevail on liability as a result of the failure to report the membership liabilities. Yet, as discussed, the AG has demonstrated liability for submitting fraudulent SFCs from 2014 to 2020 and falsely valuing the aforementioned golf clubs based on the undisclosed brand premiums and failure to report current values. All right. Vornado partnership properties. Trump has 30% limited partnership interest with non-party Vornado Realty Trust. Right. Cash liquid classifications. 30% limited partnership stake does not permit him to use or withdraw funds held by partnerships. Notwithstanding, Trump and his trustees classified his 30% interest in the Vornado partnership as liquid cash assets on his SFCs for years 2013 to 2021. This was even though it was undisputed by defendants that Trump does not have the right to use or withdraw these funds. That's a lot. That's a pretty significant. Defendants assert that even though the cash held in the partnership was misclassified and should have been reported elsewhere on the SOFCs as an asset, it would not have inflated the total value of cash for Trump's net worth, reporting the SOFCs. This argument does not hold any water. Put simply, it was false and misleading for the defendants to indicate that they had access to between $14 million and $93 million in liquid assets, sometimes nearly a third of the total cash it claimed, when in fact those assets were completely illiquid. Illiquid. Oh my gosh. Oh my goodness. All right. Here we go. We're coming down to the end. We're coming down to the finish line, everybody. All right. The appraisals. So the appraisals of the value at $2 billion as of November of 2012 and $2.3 billion in November of 2016. However, Trump's 2014 SFC calculation, his 30% share based off of purported value, was $3 billion. Based off of purported value in 2015 was $2.9 billion. 2016 was $3 billion. This resulted in overvaluations for Trump's 30% interest between $205 and $233 million for those years. That's a pretty significant difference. And then we've got more numbers here. We've got a $2 billion as of 2021 and an overvaluation again of $172 million. The instant motions do not task this court with determining which appraisals are the most accurate, which would present issues of fact. Rather, time and time again, this court is not comparing one appraisal to another. It's comparing an independent professional appraisal to a pie-in-the-sky dream of concocted potential. What? Did we just read pie in the sky in a judicial order? Come on. Accordingly, the AG has demonstrated liability for submitting fraudulent SFCs overvaluing Trump's interest in Vornado Partnership 2014 to 2016 and 2021. Licensing deals. Each of Donald Trump's SFCs from 2011 to 2021 has an asset category entitled Real Estate Licensing Deals, which the SFC represents as value derived from association with others for the purpose of developing and managing properties, and the cash flow that's expected to be derived from these associations and their potential when their potential is realized. The SFC further states in preparing these assessments, Mr. Trump and his management considered only situations which would have evolved to a point where signed arrangements with other parties exist and fees and other compensation which he will earn will be reasonably quantifiable. Despite this express language, the SFC from 2014, 2018, and 20 to 21 include variations of intra-organizational deals, all between entities under the Trump Organization umbrella in this category. It is flatly false and misleading to include values of deals between the Trump Organization entities while expressly representing in the SFCs that such assets included only valuations derived from association with others. Improperly including these intra-organization deals resulted in an overvaluation of up to $224 million in 2014 and $110 million in 2015, $120 million in 2016, $113 million in 2017, $115 million in 2018, and $97 million in 2020. Oh my gosh, that's so much. The Attorney General's demonstrated liability for the false misleading valuations of the intra-company licensing and the other loans. The AG established that the defendants submitted false SFCs after July 13th of 2014 pursuant to other loan agreements. Defendants submitted SFCs to Deutsche Bank as part of their contractual obligations arising out of 3 different loans: a Chicago loan, a Durrell loan, and the old post office loan. Defendants certified the accuracy of these SFCs to Deutsche Bank for the years 2014 to 2019 and 2021 as part of their contracted obligations. The individual defendants. The AG has demonstrated liability on behalf of all the named individual defendants. Donald Trump, as each and every SFC was issued on behalf of Donald J. Trump. Donald Trump Jr., who along with Alan Weisselberg certified the accuracy of the SFCs for 2016 to 2019. I bet he's regretting that decision. And who single-handedly certified the accuracy of the 2021 SFC. Yikes. Eric Trump, who is the listed source for the Seven Springs valuation in 2014, and who signed several guarantor compliance certificates in 2020 and 2021 for Donald J. Trump. 4, I think we can see why he didn't want his taxes released full. Yeah, Alan Weisselberg, who certified the accuracy of the SFCs from 2014 to 2021, and Jeffrey McConney, who led the process of preparing all the SFCs since the 1990s. Ooh. The entity defendants. It's settled law that a parent corporation will not be held liable for the torts or obligations of a subsidiary unless it can be shown that the parent exercised complete dominion and control over the subsidiary. Here, it's an undisputed that Donald Trump, through one corporate form or another, exercised complete control over the umbrella of entities operating in furtherance of or on behalf of the Trump Organization. Defendants do not dispute that DJT Holdings and DJT Holdings Management Member are entities that sit at the top of the Trump Organization's organizational chart and together own many of the Trump-affiliated entities that comprise the Trump Organization. DJT Holdings Managing Member LLC owns 100% of the Trump Organization, and DJT Holdings owns 100% of the Trump Organization LLC. Accordingly, the AG has established liability on behalf of all the named entity defendants: the Trump Organization, the Trump Organization LLC, DJT Holdings LLC, DJT Holdings Managing Member, as each participated in the preparation, submission, and certification of the SFCs after July 13th of 2014. Through the acts of the individual defendants as described, and 2, the DJT Revocable Trust, as both Donald Trump Jr. and Alan Weisselberg certified the accuracy of the 2016 to 2019 SFCs in their capacities as trustee. The Donald J. Trump Revocable Trust dated April 7th of 2014 as amended. Number 3, Trump Endeavor LLC, which was the borrower on the Durrell loan for which SFCs were submitted after July 13th. Number 4, 401 North Wabash Venture LLC, which was the borrower on the loan for the Trump Chicago under the SFCs that were required to be and were submitted after July 13th of 2014. Number 5, Trump Old Post Office LLC, as it was the borrower on the old post office loan under which the SFCs were required to be and were submitted after July 13th of 2014. Seven Springs and borrowing entity as described supra under the SFCs were required to be and were submitted July 13th of 2014. Whew. All right, here we go. Let's get into the injunction now. All right, so liability has been established. And the motion for summary judgment has been granted as to count 1. Now, counts 2 through 7 still need to go forward to determine questions of fact. Oh, hydrate, yes. Let's hydrate a little bit more. But now we'll get into what is going to happen because of that. So let's see what this judge has prepared here. Yeah, huge liability. Huge liability. Yeah, he lied a lot. There was a lot of lying going on. There was a lot. And the judge isn't even playing around with that. Injunctive relief. So the Attorney General has prevailed on liability on its first cause of action pursuant to Executive Law 6312. Oops. I got to double check my battery, everybody. 1 second. Just 1 second, please. There we go. All right, there we go. We should be back up and going. All right. Okay, so she's prevailed on liability on its first cause of action pursuant to Executive Law 6312, as against all defendants: Donald J. Trump, Donald Trump Jr., Eric Trump, Wesselberg, McConney, the DJ Tree, all of these trusts that we already went through. If liability is established under Executive Law 6312, the statute itself provides that the Attorney General may obtain an order enjoining the continuance of such business activity or of any fraudulent or illegal acts, and in an appropriate case, canceling any certificate filed under and by virtue of the provisions of Section 130 of the General Business Law. The Attorney General may obtain permanent injunctive relief under Executive 6312 upon a showing of reasonable likelihood of continuing violation based upon the totality of the circumstances. Citing Greenberg, further stating this is not a run-of-the-mill action for an injunction, but rather one authorized by remedial legislation brought by the Attorney General on behalf of the people of the state and for the purposes of preventing fraud and defeating exploitation. Having found at the commencement of this action that the AG had preliminarily demonstrated defendants' propensity to engage in persistent fraud, this court appointed the Honorable Barbara Jones as an independent monitor to ensure that no further fraud or illegality that violates Section 6312 pending the final disposition of this action. On August 3rd of 2023, Judge Jones reported as follows. Since my appointment, I have reviewed material financial accounting information submitted by the Trump Organization. As part of my review, I have made preliminary observations regarding certain current financial disclosures with respect to the Trump Organization's reporting of financial information. Specifically, I have observed that information regarding certain material liabilities provided to lenders, such as intercompany loans between and among trust entities and Donald J. Trump, certain of the trust contingent liabilities, as well as refundable golf club membership deposits, has been incomplete. Okay. The trust also has not consistently provided all required annual and quarterly certifications attesting to the accuracy of certain financial statements. Ooh, that's not good. In addition, annual audited financial statements for certain entities prepared by an external accounting firm list depreciation expenses. However, interim internally prepared financial statements provided to third parties for these same entities inconsistently report depreciation expenses. Even with a preliminary injunction in place and with an independent monitor overseeing their compliance, defendants have continued to disseminate false and misleading information while conducting business. This ongoing flouting of the court's prior order, combined with the persistent nature of the false SFCs year after year, have demonstrated the necessity of canceling the certificates filed under GBL Section 130 as the statute provides. Whoa. All right, okay, and we're citing the People v. Northern Leasing, denying a trial on petition and ordering the LLC respondents to dissolve upon finding a persistent fraud under Executive Law 68. Whoa. Having prevailed on liability on a standalone executive law cause of action, the Attorney General is entitled to the first two prayers of relief sought in her complaint. One, canceling any certificate filed under and by virtue of the provisions of New York General Business Law for all the entity defendants found liable, as well as any other entity controlled or beneficially owned by the individual defendants found liable herein, which and who participated in benefited from the foregoing fraudulent scheme. Can you explain that? I'll try, just a minute. Oh my gosh. Yeah, it looks like, prayers for relief is just a formal way of saying what we're asking for. So any of the certificates that allows them to do business in Des Moines, in New York, is going to be dissolved. So they're dissolving their certificates, so their allowances to practice business in New York. And two, appointing an independent monitor to oversee compliance, financial reporting, valuations, and disclosures to lenders, insurers, and tax authorities at the Trump Organization. Remaining issues to be determined at trial. Anything presented in the parties' moving papers that this court has not ruled upon in this decision and order, including determinations on liability for the second through seventh causes of action, the amount of disgorgement of profits to which OAG is entitled, and determinations on the third through ninth prayers for relief sought by the AG in its complaint, presents disputed issues of facts. So, right. So hold on. Let me just pull up what this section of the New York law says specifically, so I can give you the exact language here. So, hold on here. Okay, so any kind of certificates that allow you to conduct business in New York. Filing of certificates by persons conducting business under assumed name or as a partners. Let's see, conducting, no person shall hereafter carry on, conduct, or transact business in this state or under any name or designation other than his or her real name, or carry on, conduct, or transact business in this state as a member of a partnership unless they are given permission. So any of the certificates set out under Section 130, which allows you to do business in New York, are all being dissolved. Wow. Who's the AG? Letitia James. Yeah, that's the majority of his LLCs. Yeah, so, it's not like his businesses are being dissolved, but any of the permissions, in order to do business, in different states, you have to have different paperwork filed. And one of them for New York is you have to get permission and file a certificate under Section 130 under business law in New York General Business Law, Section 130. And that is saying you get permission to do business in New York. So all of the certificates for all of their companies are being dissolved. What do I search to find this document? So let me grab the first page again. Hold on. Where did it go? Sorry, it's a little wrinkled. Oh my gosh, this is so huge. Yeah, he's been kicked out of New York. This from doing business. None of these companies can do business there anymore. Yes. So here is the here's the cover page of it. So we've got, New York AG docket 1531. We've got, there we go, right up here. So 1531. Let me just highlight that. That's huge. Of course, they'll appeal it. And of course, they still have a trial for counts 2 through 7. But that's huge. He's basically been kicked out of doing business. All of his permissions to do business in New York are being dissolved. He can try to sell. Yeah. I mean, whatever. This just came down today. This order was just filed the 26th, so just today. And again, so this was because of a motion for summary judgment. So the Attorney General had filed this lawsuit, $250 million, and also to dissolve his ability to do business in New York. She only asked for a motion for summary judgment on count 1. There were multiple more counts, and the rest will be going to trial for a fact determination on whether or not there was intended fraudulent actions regarding insurance and various other forms. So those pieces will go to trial, but at this point, he's lost his business license. Yeah, his ability, the certificates, the permits that allow him to do business in New York are to be dissolved, according to this. Hot tea time. Yeah. Shiny Gold Building in Vegas. Yeah. This is really bad. I mean, it's a lot. Yeah. I mean, he wasn't. And as the judge said repeatedly, like, this wasn't just a situation where we fudged numbers. This was a repeated situation over and over again. So, for the reasons stated herein, it's hereby ordered the defendant's motion for summary judgment is denied, and is further ordered plaintiff's motion for sanctions is granted in part to the extent sanctioning these different attorneys for $7,500 each, no later than 30 days. Also ordered, plaintiff's motion for partial summary judgment on its first cause of action is granted in part to the extent of finding defendants Donald J. Trump, Donald Trump Jr., Eric Trump, Alan Weisselberg, Jeffrey McConey, the DJT, all of these guys here, to be liable as a matter of law for persistent violations of Executive Law 6312, and it's further ordered that any certificates filed under and by virtue of this section of the business law here in New York, Section 130, by any of the entity defendants or by any other entity controlled or beneficially owned by Donald J. Trump, Donald Trump Jr., Eric Trump, Alan Weisselberg, or Jeffrey McConey are canceled. And it's hereby ordered that within 10 days of this date of this order, the parties are directed to recommend the names of no more than 3 potential independent receivers to manage the dissolution of the canceled LLCs. And it's further ordered that the Honorable Barbara Jones shall continue to serve as an independent monitor of the Trump Organization until further court order. And it's further ordered that the clerk shall enter judgment accordingly. Yeah, 10 days. 10 days. It's done. Everybody, this judge was pretty thorough. I think this, honestly, is probably more painful for him than anything else, to have his business license revoked, essentially, the certificates dissolved, and he's going to have to move his LLCs around. I mean, there's no way that, I mean, this is his whole world, what he built his entire world on, and it has all been taken. It's done. Yeah, it's done. So all of it has to be dissolved. His ability to do business in New York. This is crazy. Right. His legacy. Yeah. I mean, I don't know what he's going to do, but at this point, and this judge, this is all on a motion for summary judgment. So this judge was like, look, we don't even need to go to trial on count 1. There's just so many clear, obvious violations that, we don't even know. We don't even need to go. A summary judgment can be appealed, sure. Any judgment can be appealed, but he's appealed it already so many times, and the judge was even citing the other appellate courts that it's been up to and kicked back down over and over and over again. How does disgorgement work? Is it like fines or sanctions? So I'm not sure exactly how disgorgement works. It seems like it has to do with the amount of monetary harm that could be assessed. So that whole debate that was going on about, this disgorgement issue was whether or not, there was an amount that could be placed on the harm that was done to the banks by inflating these numbers. And he's saying nobody got hurt. And the judge was saying disgorgement's not an issue here. That's the best of my understanding. Again, this is not my area for sure, but this to be judged this, well, I mean, he requested a motion for summary judgment that it be completely tossed out. Yeah. I mean, this is bad. This is really net worth dropped. Yeah, but I think his net worth was already not as much as it was. His daughter, okay, Ivanka was pulled out because she was not a part of the tolling agreement. So there was an agreement made between an agent who had the authority and the previous AG, or the previous person who was saying, we won't sue you as long as we can pause the toll. And so they agreed on it for years and years. And she was not a part of that agreement. So she was kicked out. So she's not in this because she wasn't part of the tolling situation. So if the statute of limitations tolling hadn't been there, she would have been involved. So it's not like she doesn't have any culpability here. It's just that she wasn't part of the tolling agreement. She can run a business. Yeah, she's not included. Can he give her everything? I don't know. At this point, it looks like it has to be dissolved. I'm not sure how this is going to be shifted around. I'm not sure. I think I'm not sure at this point. It says here, any certificates filed under by virtue of section 130 by any entity or by any other controlled blah, blah, blah is, and so on are canceled. So if it's canceled or dissolved, I'm assuming you can't completely transfer it over, these particular ones. It was ordered to dissolve, not for him. It was ordered to dissolve, not for him to not be a part of. Right. Exactly. So they have 10 days to dissolve all New York certificates. That's what it says. 10 days from the date of this order, the parties are directed to recommend the names of no more than 3 potential independent receivers to manage the dissolution of the canceled LLCs. And it's further ordered to have someone watching out for it. So all of their licenses that have been given to them all have to be dissolved in 10 days. Yeah, I went with Kushner. Poof. Yeah. I mean, this is huge. They don't exist anymore. Yeah, in 10 days. In 10 days, they don't. I'm not sure how they're going to break things down and exactly how they're going to be able to transfer things because, of course, it doesn't completely go away. I mean, they do have things in place that they can do in order to start the process of dissolving. So, I mean, the names, the entities themselves will be done, but there's other pieces that can be moved on. 10 days from today. Today was the day this order went in. Yeah, it's the beginning of the accountability. I can't think of anything that would be worse, honestly, for him than having his ability to do any business in New York taken. Absolutely taken away. What does this mean for his hotel there? I don't know. His ability to do any business is going to have to be dissolved. So I'm not sure. You're going to have to put together some kind of a plan to wind down all of these businesses. And he's got 10 days to do it. So I'm not even sure how that would look. It'll be sold off. Yeah, I'm not sure. This is the find out phase. Absolutely. Nobody will trust him. Yeah. Trump Tower. Yeah, he still has Chicago, right? This really has the effect of, you know, whatever business he was doing in New York. So any other state, any other place where he's got businesses going on, that's a different deal. This is just for New York, just for the licenses he's got under Section 130 of the New York Business Code. So that's the key to this case. Yeah, I'm not sure exactly, but oh, Greg, yes, good night, good night. Yeah, it's a really, yeah, it's really bad. I mean, for him, this situation, this judge isn't playing here. Yeah, I mean, is he fined? No, he's not fined. She was requesting $250 million. Now, what the judge said in here was that prayer would be taken into consideration, but we still have the assessment of that to be done along with the rest of the counts in the civil case. So there's not much left for that civil case. So if we look again, this was such a huge moment. So if we look here, we had our civil trial, which was set to go on the 2nd. We still have counts 2 through 9, I believe, that still need to be assessed on the intent of fraud and insurance fraud. Those things will be assessed, and then along with the damages as well. So those things still need to be assessed. But basically, this trial is over. This trial was set to go till December. And, I don't see how it would go that long at this point. Yeah, the lawyers were fined. Any of the lawyers that had signed their name onto the response briefs were all fined $7,500. Yeah, the hearings calendar. What? Doesn't everybody have a hearings calendar? Come on. Yeah, I mean, this judge, again, he had said, look, we appealed it. It came back up. It went back down. You've got all these different cases. You've got all these different things going on. And, it's bologna sandwiches. Yes, he can appeal. He can appeal for sure. But again, he's appealing to the same group he's appealed to repeatedly over and over and over again for multiple years. So the likelihood of success on appeal, I guess I'm saying, is pretty low. Because this judge was so thorough and he appealed every single thing, every step along the way, and lost all of his appeals repeatedly. And so this judge is like, part of the reason why there's a problem and you're being sanctioned is because you keep appealing inappropriately and frivolously. So I can't keep up with my own calendar. Well, fair enough. I understand. Advent calendar. Oh, that's so funny. You said he appealed on the grounds the judge was biased. Well, of course. I mean, he's going to say that about all the judges. All the judges are biased. And he's claimed recusals for all the judges except for the Florida judge. Well, except for the Florida federal case. He's asked for recusal of the other judge in Florida. So, I mean, it's a lot. Yeah, it's a lot. Thanks for doing a great job. Yes. Thanks. Yeah. I mean, it's a fascinating order to go through, everybody. Nothing here is constitutionally based, so no SCOTUS. No, this is all state law. This is all New York state law. So once it hits the highest court in New York, it's done. There's nowhere else to go. Good job. Thank you. Oh, thank you for coming. Yeah, appreciate it. Yeah, Cannon has not had a problem yet. He's not done. Thank you. Oh, you're welcome. Hopefully this was fascinating. I thought this was just an absolute fascinating order. Start of the House of Cards. I agree, Navy Vet. I agree. This is probably the most painful blow out of everything so far. The most painful. So he's going to continue. He's going to continue to go to slide down. Amazing. Thanks for this. You're welcome. Of course. No pardons. No. Nope. There's nothing. $250 million in fines. Right. All of that will be sorted out too at the end of the case. So once the case is finished up. So yeah, New York's not playing around. New York is not playing around. They're done. They're done. Yeah. And I think too, it's like, you can fudge here and there, but if you're fudging, $2.2 billion, oh, thank you. Thank you so much. If you're fudging $2.2 billion, I mean, that's a little too much for the banks. I'm not sure that that's allowable. Oh, yes, of course. Of course. Hopefully it was interesting. Jordy, I'm not sure if he has or not. I had literally just got this hot off the press and then came in here. So I think Scotland got him also. Oh, could be hurting him more than anything. That rich man. Yeah, VC, you're right. You're right. I mean, this was such a huge thing for him. This was his whole world. So this was a civil case, right? Now, a lot of the same information in this civil case transfers over to the lots of things going on in the criminal case, although that one, of course, is about the hush money being not disclosed. So we've got a big piece of that. But yeah, the New York criminal case is still going. We've got all of that. How did the banks not see this? I don't know. I don't know. I think we've really got a situation where someone's kind of talking the talk. Will this go to a jury court? No, there's no jury that will be involved. This will be tried in front of the judge. This will be a bench trial on counts 2 through 9. Oh, your dad's side are New Yorkers. Yes. Yeah, this is a really big deal. The Golden Escalator. Yeah, it's a lot. He can go to beauty school. Well, there's always more than one career in your life. What are counts 2 through 9? 2 through 9 are the questions of intentional fraud, liability, and fraud regarding insurance too. So the big one was this section that they kept talking about, 6312. So a violation of that, which led to the dissolution of the certificates. But the other counts had to do with finding that he intentionally was fraudulent and that insurance fraud and so on. Those will need to be determined about his scienter, his mens rea, or his intent on that. Could he file for bankruptcy? Of course. He knows how. He's done it like 6 times. Absolutely could file for bankruptcy. But I don't think bankruptcy is really the road he needs to go down. I mean, the fact he's just losing the businesses. It's not really about the money at this situation. It's about the business being able to go forward. Yes, well, Mike, I'm certainly not a business attorney, but I can at least take you through the language. Why isn't the IRS charging him on tax? Well, who knows, man? Who knows? He's barred from doing business in New York. Exactly, Perry. You got it. Exactly. Can't file to avoid legal issues. Yeah. I'm in Scotland, and the Scot government issued to investigate what he's got. Really interesting. Yeah, see, it really does. One of the things that I remember Michelle Obama saying right after the election in 2016 was she said, the light that shines on you as the president is the brightest light in the world. And it really uncovers a lot. And I think that is so true. I think that the light has been shown and we're starting to see what has come from that. So this is one piece. And this all came about because, he had been investigated before, but it continued to go forward because of that. Yes, Ava. Good to see you as always. So, for sure. Yeah, it was. It was pretty deliberate. I think so. Yeah, the presidency reveals who you are. Yeah, exactly. It shows, you can't escape it. There's no way to get away from that bright of a light, no matter what you do. So, wake people up. Perhaps, I'm not sure if his revenue streams will be cut or not. I'm not sure exactly how that's going to work. If he's going to basically cash out and move on or reinvest somehow. I'm not sure exactly what that's going to look like. 100,000 people a year. Well, yeah, we'll see. I'd never want that position. I agree. with the judge and said he was so mad. He was slapping the desk. Yeah, this judge was frustrated. I mean, you could tell just by his language, just repeatedly saying, how many times do I have to say this? This is completely wrong. This is also wrong. This is the wrong use of the law. This is the wrong use of the law. So he was pretty clear that he was frustrated. If found guilty of counts 2 through 9, then what? So he would be found liable. So, and I don't have, I mean, her complaint's like 200 pages long. I don't have it in front of me, but they had to do with different levels of fraud. And so if you're liable for that, you can have, you may have to pay certain things back. It just depends. In any kind of a civil case, you're trying to make the harmed party whole again. So there would be assessment as to how to make the harmed party whole. And we've got issues of fraud and insurance. So there would be an assessment of that. Can you just explain what you're showing? Sure. This is the order that came down from the judge today on the civil case out of New York, where he found there to be like a lot of fraud. And there was a lot of false information, bad information, and violations of New York business law. So he sanctioned attorneys for frivolous motions. And he also set out to dissolve any of the LLCs, and anything that have certificates or licenses through New York all need to be dissolved. So that's that. The $250 million, that will be assessed later on. Who's the harmed party? Yeah, the state of New York. This case was brought by the people of the state of New York, by law that was written by the elected people of the state of New York. How can he file bankruptcy? I don't know. I don't know about that. The people of the state of New York, they, there's no criminal charge. This is a civil case. Yep. There's no pardoning here. There's no federal court involved. There's no federal appeals involved. None of that's involved in this. This is all a civil case. It's possible, Tiffany, to file bankruptcy. I just have no idea. I mean, at this point, he's saying his assets are, over $1 billion. So I'm not sure how he would be able to do that. Yeah, he could appeal. Absolutely. There is a criminal case going on in New York with the hush money situation, but that's a different kind of case. Yeah, I mean, the state can issue a pardon, but again, this is because it's a civil case. We don't have criminal charges here. Yeah, over $2.5 billion is a lot, right? Can't civil lead to criminal. Sometimes. Why isn't Ivanka named? She's not named because she was not part of a tolling agreement that had occurred between everybody. So because she wasn't involved in that agreement at the time it was made, she was statute of limitations. She was out. So she's not involved. All of the rest of these people were all involved in the tolling agreement. Yep. What gets me is that he could have afforded to pay the taxes. Yeah. Can he appeal? Yes, he can. But he has appealed multiple times, so it's not like the court wasn't expecting that. Yeah, she bailed. Thank you. You're welcome, Wild Rose. Thank you for coming. Can he have new charges filed since the civil case went this way? I'm not sure. I mean, there could be definitely some criminal cases for fraud, but there could very well be a statute of limitations issued criminally. That's why civilly it's a different situation, because they had this tolling agreement on the statute of limitations. That's why it was able to be brought. Would an appeal hold up the 10-day order? I'm not sure exactly how that would work. I'm not sure that the appeal would stay that order or not. That's going to be specific to New York civil procedure. I just don't have that rule in front of me. I can't see him winning an appeal. I can't either. I mean, this judge cites the appellate court in his decision. So he cites them. He's already saying, look, you appealed 50 times, dude. You're out of line. What's a tolling agreement? Sure. So there was an agreement between the agent of this situation, whomever it may be, and the attorney general at the time. I think it was back in 2014. And they basically agreed like, hey, we've got questions about your business, but we will stop. We'll leave you alone and will not sue you, but you need to pause the statute of limitations, mutually agreed upon a situation. So a tolling agreement means you're tolling the statute of limitations. Any case has to be brought within a certain number of years according to the law. You can, though, have an agreement between two parties to stop the statute of limitations from running. So it just pauses it so you don't run out of time to file a suit. And so that's what they did here. They filed this mutually agreed upon contract. New York wasn't going to bring a suit. And then, the agent in charge of here said, all right, don't bring a suit. We'll just pause the whatever. We'll get our stuff in order. And then they didn't. Can the banks and insurance companies sue him now based on this judgment? I would say they're going to want to wait until counts 2 through 9 get taken care of, because that's where we've got the banks, the insurance companies, all are involved in counts 2 through 9. So they're going to want to wait for the results of that to come in, and then they probably could go forward on that. Are there people he'll need to pay back? Probably, I would imagine. Maybe they paused it while he was president. No, this was paused. The tolling agreement I thought I had read was done actually in 2014. So that's where we got that 2014 deadline here. So 2014 to 2018. So the tolling agreement came before that. He tried to reform the businesses under Ivanka or someone else's name. Could New York deny them? It's possible. It's possible. It definitely goes beyond my knowledge of New York business law. I would think that there would be a way to kind of carefully craft his way around it, but I'm not sure what that would look like at this point. Bunch of chores around the apartment. I can't believe you. Yes, of course, Dan. Of course. We're here. We're talking about New York. You got to take care of business. So the judge ruled on count 1. Yes, and count 1 was the only count that the Attorney General asked for a motion for summary judgment on. She wanted counts 2 through 7 to go. She didn't want those to be included in the motion for summary judgment. So she specifically only asked for count 1 to be decided, and that's what the judge did. I went to 2 jobs and you're still here. True. Doesn't have good lawyers anymore. They're all being sanctioned and brought to trial. Yeah, there's a lot of sanctions going on for sure. For sure. You spend more time on these cases than Trump's attorneys do. It could be, Dan. It seems like it sometimes the way these motions are written. I'm like, what? Did anybody research this first? Oh my gosh, that's so funny. Yeah, it's true. When did the college fail? Yeah, that was back in 2000 and, was it 15? Was it 16? I can't remember exactly. That's a good point though, isn't it? Marathoner. Yeah, good point. When did this case start? It started years and years and years ago. It started a long time ago. So let's see. We had a special proceeding in 2020, but it looks like, it looks like told the statute of limitations from November 5th of 2020 through May of 2022. So it looks like we did have that in here, but yeah, it's been going on for a while now. Oh my goodness. So we had a partial, so we had so it looks like there was an investigation going into business practices that defendants engaged in from 2011 to 2021. That's how long the investigation was for this period of time. And so there were just so many multiple pieces. And then this section of the New York law is the key as well. How is it that Ivanka keeps getting away with it? I don't know. But we've got here, the Trump Organization entered into an agreement which, broadly speaking, told the statute of limitations from November 5th of 2020 to May 31st of 2022. So it bumped 2 years off of the statute of limitations, which allowed this case then to go forward. Apparently, and I thought it was earlier than that. I thought it was in 2014, but I was wrong. It looks like it was November of 2020 to 2022. So allowing this amount of time to be put back in allowed them to bring this case. So they weren't outside of the statute of limitations. She was not involved in this agreement. So with the Trump organization entering into this agreement, she was not part of the Trump organization on November 5th of 2020. That's why she was bumped out. Wish all my law professors. Oh, thanks. Oh, that's so sweet. Yeah, yeah. She was just in time. Yeah. Yeah, a lot of that came through. 10-year statute of limitations. Okay, thanks. Yeah, I was wondering what that statute of limitation number was in New York. What if Ivanka's a mastermind? I don't know. I don't know. She's doing a great job then, because she's not getting into any trouble. Yeah, I think this is a pretty huge blow here. A perfect judge's order. True. I agree. Is it going to stick? Yeah. They'll file appeals. True. But again, in this judge's order, he is citing the appellate court over and over and over again. He's saying, as the appellate court said repeatedly over and over and over again, people. So I don't think it's going to be an issue. Yeah, I agree. So it's huge. Yeah, it's huge. Yes. Well, everybody, I'm starting to feel my voice go. So I'm going to have to kindly say my good nights at this time. Oh, sorry. I knew my voice was going to be a little bit short for tonight, but so we were able to get through his response, right? So we had his response to the DC order, and then we have this judge's order out of New York. So let's just review real quick what's going on this week. We've still got all motions that are not in limine for Chesebro and Powell are due Wednesday. We've got Meadows' reply brief is due Thursday. Friday, we've got case management. And we've got the government's response to defendants' opposition to this gag order. So that's due. And then next week, then when that civil trial is to begin, we've got counts 2 through 9. So we'll see what happens from there. Yes, thank you everyone for coming tonight. It was always good to see everyone. And yes, it will be very, very busy. Yes, I'll need to have some tea. Yes, this was a lot of great information, but this judge was amazing. He did a really good job. So, yes. I will be, yes. Oh, I'm so glad you all could come. And my moderators, you're all fantastic. I've got a couple of videos in the hopper for my Tube of You channel, but should be back up as scheduled here pretty soon. So, I'm still live, but I'm heading out. But thank you, everybody, for coming by. Yes, and we'll see over the next few days what's going to happen. But we've got the full language of the order, so we know what's going on. So, cheese and crackers. Yep, cheese and crackers. Yes, you're welcome. You're welcome, everyone. Yes, this has been a great night. I appreciate it. I appreciate everyone taking their time to come and hang out with me. I'm going to have to stop talking here pretty soon. But it's been great. Yes, good night. Good night, everyone. I will keep you posted as we go further here. So as the next few weeks come on, we've got, again, our big trial set for the 23rd in Georgia. That'll be our big criminal trial. So we'll see what happens there. So yes, so this week we've got a full week, and then into October here we've got several things going on as well. So I do have a post up on the calendar for anyone who's interested. But thank you all again for joining. It was good to see everybody and fun to hang out. So I'll go ahead and sign off for tonight. Get some rest. Yes, hopefully I'll be able to come back on tomorrow. I've got to go, everybody. Have a good night. Oh my gosh. It's been great. Take care, everybody.